and permission, one matter, end of the list. The reason is this one. The exams are a petitioner applied for gazetted probationer's recruitment notification. There's some discrepancy in making the payment, not the application has been not accepted. Application submitted successfully, Lord, but the fees is not accepted. That's the reason, Lord, have been denied the rejected the apply.
What is the urgency for the day?
But 27th is the exam scheduled, my lord, and
Yes,
before
please see.
1:30, my lord, I will assure that, my lord, I will
Must be served on the other side also.
not government, my lord, and the KPSC. I'll serve on the KPSC also, my lord.
See that they are here.
Yes, my lord, I'll.
If it comes before one.
Please, my lord.
Lots, serial number 33, list 1.
Just a moment, just a moment.
Any mentioning? List 1, page 1, symbol 1 to 5.
Serial number 3, my lord.
2, my lord.
It makes sense.
Yes. Serial number.
Serial number 2, pray for a week's time for respondent number 1, my lord. Pray for a week's time, a specific date may be given. The senior is unwell, I can file a memo to that extent.
Yes.
Serial number 3, my lords. Senior is not keeping well, my lords. A week adjournment will be given, my lords.
Yes.
My lord, serial number,
Yes,
Serial number 4, your lordship. I appear for the appellant. Pray for 2 weeks time, your lordship.
4.
Everything is good.
For
Yes.
respondent, my lord.
Page 2, number 6 to 12.
Number
Page-
10, my lord.
Number?
10.
Serial number 8.
Yes, serial number 8.
My lord, I pray for 2 weeks time. Lord, serial number
Number
8, I
10,
pray for
man.
private respondent. Lord, that is covered, Lord. In fact, last week, Lord, not the disability quota. My lordship not covered.
Did it come after a week? Is it a covered matter?
Yes, Lord. I have the Lord, copy. In fact, Lord,
I have
none.
got instruction on that. They have not replied.
Yes.
Serial number 10, my lord.
Yes.
Next week, not any date.
Next week, any day.
14.
Serial number 10.
What is 10?
That's a perfect income.
You inform the other side?
I'll inform you.
Only government. No, no.
Oh, private part.
Yes, private party is there. Please inform the other
I'll
side.
inform you.
Yes.
Page 3, 13 to 16. Page 4, 17 to 19.
18, my lord. And for the petitioner in this case, in 18, Prasanth Shetty.
I'm appearing for respondent R3 minutes.
And be on some other
Which time
day.
it is? In this case, my lord, I may be permitted to serve the copy on 18 and 18.3, my lord, because earlier council Manjula D is appearing, now Prasanth Shetty appearing for R3. I may be permitted, my lord, in that.
Yes,
Interim order may be extended.
yes.
Page 5, 20 to 27. Page 6, 28 to 33.
Lord, serial number 33. So seek for a 2 weeks adjournment. Seniors having some personal inconvenience.
Serial number 32, your lordship. I'm for the appellant. Kindly have it next week, your lordship.
Anyway, not be taken up. File hearing matters.
Ah.
Yes.
Next week, your lordship. 16, please.
Permission, Lordship. Serial number 16 and 17. So with regard to counseling of medical law, yesterday in one of the case, the tribunal has passed an order. Lordship, we are also challenging for that. It is connected to that. Lordship, today we are filing. Lordship, have it on 20. Because the issue is now your Lordship has said that they will get an opportunity in the second round.
Yes.
Now the executive order is passed by the government, holding that irrespective of priority list, they will be allowed to first. That apart, the entire Bangalore unit has taken as one. The zone wise are different zone. That is the reason your Lordship there's a bearing for all the. I request your Lordship buy it on 28 because we are also challenging that because we are filing together because they cannot be separated with us is the only issue. And there cannot, the entire medical offices is one unit. Bangalore is not a separate unit. That they, by virtue of an executive order, when the field is occupied, the tribunal accepted that it is illegal, but still they directed to hold counseling as per act, but they never say the executive order. And the government says that we are going with the executive order. That is the reason, Lordship, on 28.
Land Council is fair in his submission, my lord. They are, by virtue of the notification,
Zone A says that every district should be included, but they have included only.
Only Bangalore.
Bangalore, that is there. But even yesterday I brought it to your lordship's notice that they have reduced from 15% to 5%. Act contemplates that 15%.
It is all in one executive order.
One
executive order,
one
because
executive order.
It is under
Act-
challenge and.
that we have challenged before the tribunal. Tribunal accepted the same, but they are not stayed and directed to hold the counseling as per act. If it is as per act, we are agreed for that. But the executive order is request to be stayed. That your lordship on 28th.
Shall we have this on 28th then?
Can it be on the beginning of first week of?
Because the.
But 31st is the last date,
The
madam.
difficulty is that the counselings are on. And once the counselings are complete.
AG is appearing in this matter.
No, your lordship, they have conducting by phrase wise. Now they are holding for pharmacist. Lost is the medical officers. It will take state in view of the lordship has seized of the matter. Lordship have turned because that executive order is binding on the government to hold on that counseling. Only in that issue we are right before the court.
Also, the entire process,
Take for the date with the AG.
Yes.
Obliged.
Inform the others also.
29th will be,
29th, your lordship on 29th.
29th will be.
Instead of
continued.
29th, your lordship,
I'll just. quote
Please.
30, instead of 29th, either 30th or 28th. your lordship.
30th also.
30th, I have no objection.
Any of the 3 days, I'll just.
Yes.
No,
Not on 29.
excluding on 29th. Obliged, lordship.
Please. Interim order
30th
has
is
to be
okay.
extended.
30th is okay. 30th is okay.
Interim order has to be extended.
Details.
It will be.
Please, 16
Obliged.
My lords, with your permission, it's a memo for posting in a fresh matter. There is a urgency in this matter because the arbitrator wants to resume the arbitral proceedings on the 28th. I have filed IE number 1 for a stay of the proceedings.
Monday.
List 1, admission, seal number 1, Mubarak Begum.
Wait, please, your lordship. Your lordship, on the last date of hearing, my learned counsel has submitted few judgments in wherein it stated that the matters pertaining to IP related cannot be arbitrable. In fact, my lord, your lordship directed me to answer those. My lord, in these judgments, my lord, the judgment passed by the Honorable Supreme Court, Booz Allen versus and Hamilton Inc. versus SBI Home Finance Limited is broadly discussed in all the judgment, my lords, which is a prominent judgment passed by the Honorable Supreme Court, which clearly states the matters which are arbitrable and which are not non-arbitrable, my lords. In fact, the present matter, my lord, which is clearly falls under the category of rights in personam, my lord, which is not falls under the category of rights in rem. I am seeking the relief against particular person, not against the world at large.
What is the relief you're seeking against a particular person?
My lord, it is, in fact, not against me. The relief sought against me was infringement of trademark and also the infringement of music composition, not to use the music composition. This is the particular relief sought against me by the plaintiff and the defendant, claiming the rights and interest in the trade name Mother Jane, my lord, and also music composition by virtue of assignment deed, my lords. In fact, my lord, this clearly, the dispute arises clearly a contractual dispute, my lord. It's a purely a contractual dispute arising out of two documents, two contracts. Therefore, my lord, this cannot be falls under the category of rights in rem. Therefore, this judgment, the judgment which my learned friend has given, A. Ayaswamy versus Paramashivam, which purely deals with fraud, my lord. The matters related to fraud or misappropriation, which are criminal in nature. The entire judgment deals with the fraud, and in fact, it is remotely connected with the IP related matter, my lord. This judgment.
Question is simply this, can an infringement suit?
Yes,
the
my lord.
subject matter of an arbitration?
This matter is purely arbitrable, my lord.
Please don't answer on, please tell us whether an infringement suit would be arbitrable.
Yes, my lord.
If the list is on the basis of a infringement of a trademark, is it arbitrable or not? Is that the prayer they've made against you?
Yes, my lord. My lord, the judgment submitted by Landfed, I am also referring to those judgments.
Hmm.
My lord, kindly see, my lord, page, the judgment which passed in Vidya Drolia and others versus Durga Trading Corporation.
Hmm.
Wherein this judgment, my lord, the detailed discussion has been taken place.
Hmm.
And the judgment passed, previous judgment passed by the Supreme Court, Booz Allen and Hamilton Inc. versus SBI Home Finance, wherein it clearly discussed about the matters which are arbitrable and which are non-arbitrable, my lord,
Hmm.
and how it will be arbitrable.
Hmm.
Therefore, my lord, kindly see, my lord, page 136 of the judgment submitted by my lord.
Suggestions. Yes.
Page 136, my lords.
Hmm.
May I permit it to read? my
Hmm.
lord? Para 34, my lords.
Hmm.
In Booz Allen and Hamilton Inc. Elucidating on the question of non-arbitrability of dispute, it has been observed. Para 35 of this judgment has been extracted, my lord. The arbitral tribunals are private fora chosen voluntarily by the parties to the dispute to adjudicate their dispute in place of courts and tribunals, which are public fora constituted under the laws of the country. Every civil or commercial dispute, either contractual or non-contractual, which can be decided by a court, is in principle capable of being adjudicated and resolved by arbitration unless the jurisdiction of the arbitral tribunal is excluded, either expressly or by necessary implication. Therefore, my lord, there is no express bar on the matters relating to IP disputes, my lord. There is no express bar on that. That should not be arbitrable.
Mm.
Then, my lord, adjudicate.
Certain categories of proceedings are
Adjudication-
reserved by the legislature exclusively for public fora as a matter of public policy.
Yes, may I continue, my lords?
Mm.
Certain other categories of cases, though not expressly reserved for adjudication by public fora, courts and tribunal, may by necessarily implication stand excluded from the purview of private fora. Consequently, where the cause dispute is inarbitrable, the court where a suit is pending will refuse to refer the parties to arbitration under Section 8 of the Act, even if the parties might have agreed upon arbitration as the forum for settlement of such disputes. My lord, next paragraph, para 37 of this judgment. It may be noticed that the cases referred to above related actions in rem. A right in rem is right exercisable against the world at large as contrasted from a right in personam, which is an interest protected solely against specific individuals. Actions in personam refer to actions determining the rights and interest of the parties themselves in the subject matter of the case.
Therefore,
lord-
contention is that what is under dispute is a assignment of a trademark and not the infringement.
Which
thereof.
should not be against public at large, my lord. And this is not relief against public at large. It is a rights in personam. It's a purely contractual dispute between the parties, my lord. May I continue, my lord?
Yes.
Whereas the actions in rem refer to actions determining the title to property and the rights of the parties, not merely among themselves, but also against all persons at any time claiming an interest in the property. Correspondingly, a judgment in personam refers to a judgment against a person as distinguished from a judgment against a thing, right or status, and a judgment in rem refers to a judgment that determines the status of condition of property which operates directly on the property itself.
Yes.
Para 38, my lord.
Hmm.
Generally and traditionally, all disputes relating to rights in personam are considered to be amenable to arbitration. And all disputes relating to rights in rem are required to be adjudicated by courts and public tribunals, being unsuited for private arbitration. This is not, however, a rigid or inflexible rule.
Yes.
My lord, in page number, same page, my lord, para 37, my lord. of this same judgment. Booz Allen and Hamilton Inc. draws a distinction between actions in personam, that is, actions which determines the rights and interests of parties themselves in the subject matter of the case, and actions in rem, which refers to actions determining the title of the property and the rights of the parties not merely amongst themselves, but also against all the persons at any time claiming an interest in the property. Rights in personam are considered to be amenable to arbitration, and disputes regarding rights in rem are required to be adjudicated by the courts and public tribunals. The latter actions are unsuitable for private arbitration. Disputes relating to subordinate rights in personam arising from rights in rem are considered to be arbitrable. Para 36 of the judgment in Booz Allen and Hamilton Inc. refers to certain examples of non-arbitrable disputes and writs. The well-recognized example of non-arbitrable disputes are disputes relating to rights and liabilities which gives rise to or arise out of criminal offenses, and matrimonial disputes relating to divorce, judicial separation, restitution of conjugal rights, child custody, guardianship matters, insolvency and winding up matters, testamentary matters, grant of probate, letters of administration, and succession certificate. Number 6, my lord, eviction or tenancy matters governed by special statutes where the tenant enjoys statutory protection against eviction, and only the specified courts are conferred jurisdiction to grant eviction or decide these disputes. My lord, therefore, the list is very clear, my lord, and there is no express bar on the IP related matters that cannot be arbitrable, my lord. A clear distinction is made in this judgment, my lord, which are the rights in rem and rights in personam.
What exactly is the relief sought for in the suit?
I may be permitted to read, my lord. Lord, plain page 181, my lords. Yes. 181, prayer, my lord. An order for permanent injunction restraining and enjoining the defendants, their partners, principal officers, servants, and agents, and all other acting on its behalf, as the case may be, from utilizing Mother Jane and any other deceptively similar mark belonging to a plaintiff by virtue of deed of assignment deed dated 30th August 2008.
Yes.
An order for permanent injunction restraining the defendants, their partners, principal officers, servants, and agents, and all other acting persons on behalf from utilizing, from performing the copyrighted compositions and songs vested with the plaintiff by virtue of deed of assignment deed dated 30th August 2008. Then, my lord, page 182, my lord. An order for rendition of accounts in respect of revenue derived by using the trade name, brand name, goodwill, and copyright belonging to the plaintiff under the deed of assignment deed dated 2008, including but not limited to the music shows identified by the plaintiffs, and decree of amount so found due in favor of the plaintiff till date. And then, my lord, they have sought for the damages of 5,50,000. These are the reliefs sought by the plaintiffs. This is purely
Yes.
My lords, there are three contentions that have been raised by my learned friend, one today and two on the last date of hearing. I'll just take 5 minutes to address those. And the first contention is that this is only a dispute involving the two parties before this court, and it's a right in personam and not a right in rem, which is required to be adjudicated. My lords, that is not correct in these circumstances, at least in this dispute, because the appellants have also challenged my ownership of these legal rights as well. So the IPR rights in this matter are twofold. One is the trademark Mother Jane, and the second is the copyright to the songs which have been performed by the Mother Jane as recorded in the assignment deed. My lords may recall those are described in the schedule therein. The appellants herein have disputed ever executing this assignment deed itself. That is reflected from the written statement. If I'll just take a moment to read that. This is at page 225 of the appeal paper book.
Yes.
Para 7, my lords.
Yes.
May I read?
Hmm.
That the plaintiff is illegally and falsely claiming the ownership, copyrights, and intellectual property rights over the music contents of music band Mother Jane by virtue of the alleged assignment deed, which he has obtained fraudulently by taking undue advantage of the trust and faith the defendants had on plaintiff. The defendants never knew the ill intentions and the motive of the plaintiff behind creating this assignment deed. Hence, the suit filed by the plaintiff based on the said assignment deed is not maintainable and the same is liable to be dismissed. My contention is that when my ownership of the rights is being alleged and infringed by the appellants, it is not merely a question of infringement alone. The court or the any other forum which would be hearing this matter would also have to decide the ownership of these intellectual rights flowing to me pursuant to the assignment deed, and second, their infringement, if any, by the appellant. Section 39 of the Trademarks Act, I may just draw reference to it briefly.
Yes.
Assignability and transferability of unregistered trademarks. An unregistered trademark may be assigned or transmitted with or without the goodwill of the business concerned. My lords, in this case, after this agreement was executed in 2008, subsequently, I had applied for a registration of trademark, which expired with the efflux of time. I have applied again in 2023 for the registration of trademark. But as of now, my right to derive the title to this trademark flows from the assignment deed alone and pursuant to section 39, by which the appellants who are parties to the assignment deed have assigned this trademark to me. Also, allows the second limb of the intellectual property rights involved in the matter are the copyright songs. So copyright does not require separate registration. Once it is acknowledged publicly, the right flows to me. Now, there were two albums which are in particular involved here, which were released prior to around the time the agreement was registered. Those albums clearly record that the copyright for such songs belongs to me. Hence, these are the two intellectual property rights assigned here. Now, the appellant is claiming that by the assignment deed, I have never executed the assignment deed itself. And hence, he's claiming a challenge to the ownership of my IPR rights, and second, also alleging fraud. Of course, that is a subject matter of trial, and the learned trial court already, while passing the injunction order against the appellants, has already taken note of this contention. And while he has left the issue open to be decided in trial court, he has prima facie observed that the contention of fraud has to be proved during trial before it can be taken further. Whereas my humble submission is this is not a matter where only right in personam is involved, but there is a right in rem. And secondly, my lords, the paragraphs, the relevant paragraphs that were read by my learned friend, they are extracted from the Booz and Alan Hamilton case, which preceded this very judgment. I will not read those paragraphs again, where the learned Supreme Court has clearly observed that disputes regarding IPR rights are not within the domain of arbitration. And my lords,
Their contention is not that IPR rights are arbitrable. Their contention is that it is not IPR rights per se that they are that is the subject matter of the dispute. It is the contract of assignment of IPR rights. It's a contention.
My lord, that contention is not true based on what the stand that has been taken by them in the written statement. And also in the CMP petition, unfortunately, we can produce that record. The prayer sought in the CMP petition for reference to arbitration, clearly in the prayer itself says that there is a reference to requiring the adjudication of the intellectual property rights of the parties. Of course, that's an independent matter and that will be separately decided. But from the Section 8 application also, if I may read that again for a moment. Annexure S at page 190.
Yes.
That's para 14 at page 199 of the Section 8 application. I further state that there's a typo here, it's Mr. Suraj Mani, himself proposed for the execution of certain documents without even disclosing his intentions and hidden agenda for the same, but by falsely assuring that the said documentation is only for the benefit of the music band and for financial gain. The fact he himself admitted in his pleadings in the IA file under 17 of the Arbitration and Conciliation Act, filed before the arbitrator in the case of 1 of 23 at para 10. There are several other averments which are in the Section 8 application where they have challenged the ownership of my IPR rights, as is visible from para 7 of the written statement also.
Yes.
It's my humble contention, my lords, that this is not an issue where only rights, because if, assuming for a moment, tomorrow an arbitral tribunal decides that the assignment deed is not correctly executed, then it would not just affect the appellants herein, but my rights against everyone at large. Hence, it's not a right, it's not a matter where only rights in personam are involved, but also rights in rem are involved. My lords, I'll also like to highlight that the Section 17 application, which was read out by my learned friend on the last date of hearing, was filed before the arbitral tribunal. As such, this document is not admissible before this honorable court pursuant to Section 42A of the Arbitration and Conciliation Act.
Yes.
If I may read that out for a.
Yes.
I beg your pardon. Notwithstanding anything contained in any other law for the time being in force, the arbitrator, the arbitral institution, and the parties to the arbitration agreement shall maintain confidentiality of all arbitral proceedings, except award, where disclosure is necessary for the purpose of implementation and enforcement of the award. My lord, this Section 17 application, which was read out, is a part of the arbitral record that which could not be disclosed except for the purpose of enforcement and for challenge of the award. Notwithstanding the same, I'm not stepping away from my contentions in the Section 17 application. There was a suit filed by the appellants before the Ernakulam court in Kerala, where they had sought an injunction against infringement by me. That suit was Subsequent to that, arbitration proceedings were initiated. Hence, at that time, these contentions were relevant. Subsequently, the appellants also filed a Section 9 application before the City Civil Court in Bangalore, asking for an injunction. This injunction was initially granted ex parte, but was subsequently vacated. And one of the grounds on which this injunction was vacated against the appellants was their suppressal of the proceedings before the vernaculum court, which has also been the conduct of appellant throughout these proceedings. They have been continuously initiating multiple proceedings in order to evade any injunctive rights. Even today, there's an injunction that is operating against them by order dated 7th Feb 2024 by the Learned Commercial Court in the very suit which is a subject matter before this honorable court. They appeared before the commercial court. More than 6 to 7 hearings were conducted. Once they failed, an injunction was permanently granted against them till the disposal of suit. Now these arbitration applications have come.
May I know this?
My lords, also by filing of the vernaculum suit, they also submitted to the jurisdiction of the civil court in terms of the contentions before involved in these agreements.
The
My lord.
suit there was in respect of?
My lord, it was the injunction suit that was filed by them.
They filed an injunction.
They filed an injunction suit asking for injunction against me from using the copyrights and trademarks.
May I, my lord?
Yes.
My lord, sir, the suit which was filed is not a part of this record, my lord. In fact, the suit was filed prior to the initiation of the arbitration proceedings, my lord. Prior to the initiation of arbitration proceedings by the plaintiff, my lord. In fact, it was filed and later it was withdrawn, my lord.
Is withdrawn.
Yes, my lord. Later withdrawn. It was filed not to use the my lord, not to use the name of the trademark. It was filed for some other purpose, my lord. I don't have the record, my lord. In fact, the suit was filed for deceptively or for making the reputation, harming the reputation of Mother Jane, my lord. Restraining the plaintiff from harming the reputation of Mother Jane. The prior was entirely different. Later it was withdrawn, my lord. Then, my lord, the arbitration proceedings have been commenced. I have received the notices, then I have replied, then I appeared before the arbitration proceedings. Then I filed my IA, I challenged the appointment of the arbitrator, sole arbitrator. Later, he has been recused from the proceedings on the ground which I filed by IA. Immediately after he recused, the arbitral decision was passed. I issued a notice under arbitration, my lord, notice of dispute. Then, my lord, the plaintiff have replied refusing the name suggested by me. After that, my lord, immediately I filed the civil miscellaneous petition seeking an appointment of arbitrator by virtue of the deed of agreement, which is an arbitration agreement, which is pending before this honorable court, my lord. And then, my lord, the Section 9 application, which I have filed for interim measures under Arbitration Act only, my lord, which I can file under Arbitration Act. I have not gone beyond the purview of the arbitration proceedings, my lord. My lord, Section 42A regarding the confidentiality of the information. This section deals, this only protects against the third party interest or public at large, my lord, not sharing the confidential information to any third party regarding the proceedings. My lord, I have produced this document before this honorable court, which is very relevant for taking the proper decision and merits to decide the merits of the case, my lord. And this court, this section is not applicable, my lord, because the document is relevant and it is only for the protection of the parties against the third parties, my lord. It has to be interpreted in that way, my lord. Therefore, my lord, Section 42A is not applicable in this case, my lord.
Yes.
And the document what I have relied, which Section 17 application filed by the plaintiff before the arbitration, which clearly says that the relief sought before the arbitration proceedings and also before the commercial suit is both are same and similar in nature, my lord. And in their pleadings, they have clearly admitted both the documents, deed of agreement and assignment deed, both are to be read together and are interlinked. Now they cannot say that the assignment deed is different and the arbitration deed is different. And the disputes, they cannot differentiate, my lord,
Yes.
as per their convenient, my lords.
Yes.
My
Only
lords, may I
question,
just
my
make
lord,
a one
here.
short rejoinder. By mere reference, an arbitration clause does not get incorporated from one agreement to another. Section 7 of the Arbitration Act deals with that. In my judgment compilation, the second judgment, MR Engineers, I have filed on that aspect. Because a mere reference,
Please make available, both of you, please make available a short synopsis.
please, my lords.
Please,
Your
my lord.
points as well.
Please.
My lord, I also have the copy of the Arnaculam suit. May I place it on record if my lord permits?
I will also place it on record,
We-
my lord. I may be, my lord, in fact, I will.
Both of you don't have to place the same thing on record.
No, I have it
Yes.
on me now. I can place it on record now along with it.
We list it on Wednesday. Please make available the synopsis, both of you.
Please, ma'am.
Please,
Yes. Short synopsis, please, just your points.
please.
Yes. Wednesday at the top of the list only for accepting the synopsis.
My lord,
Wednesday
the
at the top of the
synopsis,
list only for accepting the synopsis, your points, so that we don't miss out anything.
please. Great.
Preliminary hearing, 2, 3, 4 urgent, 5. Priyanka S. Sangadi.
I appear for the petitioner, my lord. My lord, this petition is arising out of an order passed by the Honorable KAT with respect to direction seeking regularization of services of the petitioner. My lord, the petitioner was appointed as a daily wage worker on 7/2/1987 against a sanctioned post in the Department of Health and Family Welfare on 7/2/1984, and he had the eligibility criteria, my lord. Now, his appointment letter I have produced at Annexure A1, which is at page 54, my lord. Page 54, my lord. Yes, my lord. ಹಾಸನ ತಾಲೂಕು ಉಪ್ಪಳ್ಳಿ ಗ್ರಾಮದ ಶ್ರೀ ಚಲುವೈಗೌಡರ ಮಗ ಶ್ರೀ ಯು.ಸಿ. ಶೈಲಜೇಗೌಡ ಇವರನ್ನು ಗ್ರೂಪ್ ಡಿ ನೌಕರಿಗಾಗಿ ದಿನಕ್ಕೆ 8 ರೂಪಾಯಿಯಂತೆ ದಿನಗೂಲಿಯ ಆಧಾರದ ಮೇಲೆ 29 ದಿನಗಳ ಕಾಲ ನೇಮಿಸಿ ಸರ್ಕಾರಿ ಆಯುರ್ವೇದ ಆಸ್ಪತ್ರೆ ಉದಯವಾರ ಸಕಲೇಶ್ಪುರ ತಾಲೂಕು ಇಲ್ಲಿ ಖಾಲಿ ಇರುವ ಗ್ರೂಪ್ ಡಿ ನೌಕರ ಹುದ್ದೆಗೆ ತಾತ್ಕಾಲಿಕವಾಗಿ ನೇಮಕಾತಿ ಮಾಡಲಾಗಿದೆ. This was an appointment. Vacant post. This was an appointment on compassionate ground as his wife passed away while undergoing family planning operation. Hence, he was appointed as a daily wage worker, my lord. He approaches Honorable High Court and seeks regularization of the services through writ petition number 36498 of 1998, which is produced at page number 201, Annexure R6. 201 may kindly be looked into. 201.
Yes.
R6. My lord, this writ petition was filed in 1998 seeking direction for regularization of his services. The operative portion of the order is at page 209, wherein it says that for the reasons stated supra, it would be proper and appropriate for this court to give direction to the respondents to consider the claim of the petition on the basis of the government order and Dharwad District PWD LW Association case and pass appropriate orders within period of 3 months after examining the claim of the petitioner for regularization of his services. This order was passed on 27/3/2000. Subsequently, my lord, his services were not regularized. So he files another application before the Honorable KAT, which is numbered as application number 2159 of 2001, which is produced at Annexure A7, my lord, page 72. Page 72, my lord. he approaches Honorable KAT for seeking once again regularization of his services. The operative portion of the order is at page 75. The respondent shall have to examine the claim of the applicant for regularization of his services if the applicant has worked for 10 years or I will serve proper.
Please serve a proper,
Please.
yes, learned counsel for
Date may be
petitioner
fixed, my lord. I will serve copy today itself.
shall serve a proper copy of the writ petition complete in all respects, the learned government advocate during the course of the day. List next week.
Kindly have it on 11th, my lord. Date may be fixed. Please, my lord.
Yes,
Please.
Six.
Here for the petitioner.
yes.
Right, I'm sorry, Manoj. I have never opposed for any
What is
adjournment.
the issue here?
Let suspension, Manoj. Just have a look at the order sheet, Manoj. For over 2 years, I am placed under suspension. No, never. In fact, it was adjourned at their request saying AG will appear and then AG will appear and then again AG will appear. Just have a look at the order sheet. It can be passed over.
So,
Great.
7. Srikanth MP.
Lords, for 15 years time on, Lords, request was made. Lords, he joins, Lords, the education department after being relieved, Lords, of his services in the army. After he, Lords, joins the department, there will be a dispute insofar as pay fixation is concerned. His case was that, yes, I should be fixed in the minimum of the pay, but certain benefits to be given. He approaches the KAT, Lords, his extended benefit. Pay is fixed. While fixing the pay, Lords, because he reached the maximum in that pay scale, he was also given stagnation increments. Subsequently, Lord, there is revision. Fact remains that he is given 10 years time bound. He is 6 months, 15 years time bound. Clarification is sought by the block education officer. That goes up to the director. Director says, no, it is, you should consider and give the endorsement. Now endorsement is issued saying that you reach the maximum of the pay scale. As such, we are rejecting your request. My lords, I approach the Honorable Education, that is Karnataka Administrative Tribunal. Tribunal rejects, my lord, saying that you reach the maximum. Lords, the rules, my lord, does not say that I should not have reached the maximum of the pay scale. What is required under the rules is I should have put in 15 years of service without having any promotional, my lords, avenue. Even let's assume, I mean, in my case, I make a representation saying that I have not reached the maximum of that scale, Lords, repeatedly. Those representations are not considered. But an endorsement is issued when I challenge, Lord, it is also rejected, saying that I did not place another endorsement. The tribunal says I did not place the endorsement dated 13/6/2023. That happens to my lords, a communication from the BEO, my lords, to the directors seeking clarification. My lords, I'm not a privy to that. My lords, without considering, without appreciating, my lords, the contention, the tribunal rejects, my lords, and as such, my lords, I am before the school. It is for them to respond, my lords.
Lord, it appears it has been dismissed at the threshold. The government hadn't had an opportunity to file statement of objections. I've gone through the impugned order, my lord. It appears in the writ petition, the petitioner has even disputed the statement in the endorsement that he has reached the maximum pay scale. In para 24 at page 24.
If he has not reached the maximum of the pay scale, then definitely.
So that's a factual claim which has to be verified, my lord.
In
I
fact,
think
after
matter has come up
endorsement,
for the
I
first time.
repeatedly made representation,
Note
they are
to
not
be reached.
considered.
I'll
Yes.
secure instructions and reply.
Advocate takes notice on behalf of of all the respondents?
Lord, state can appeal.
Yes.
Yes, the respondents and seeks time to get instructions and to place a statement of objections on record in the writ petition. List after 3 weeks.
3 weeks. Grateful.
8 adjourn, 9.
8 minutes.
Good thing.
Yes.
Matter pertaining to suspension of teacher,
Suspension of?
assistant teacher, not annexure A1, my lord, on 2/4/2012.
Yes.
My lord, application was called for to fill up the post of, my lord, assistant teacher grade 2.
Yes.
Lord, I responded to the notification and 22/12/2014, Lord, I was appointed as assistant teacher
Yes.
by operating, my lord, additional list. Lord, the allegation is pertaining to, my lord, the additional list. Lord, probationary period was declared on 2/3/2017.
Yes.
Lord, on 17/5/2023, petitioner was placed under suspension on the ground that, Lord, my name did not find place in the original list. I have Lord, deceived the state government, colluded with the employees of the state government, got the appointment illegally, is the, my lord, sum and substance of the allegation. Suspension is dated 17/5/2023. Lord, I approached the tribunal. Tribunal did not grant me an interim order. Against that, my lord, I preferred writ petition. My lords will find the order at annexure A9, page 136. Lord, this honorable court observed that allegation is a decade old. Therefore, page 139, my lord, para 4. We have perused the impugned order of suspension. It is alleged that petitioner who was appointed in 2014 has been appointed despite the fact that name of the petitioner was not found in the select list. In fact, it has been observed that candidature of the petitioner has been rejected as a mark secured by her, himmantagu. Her was below the cutoff percentage. The allegation are 10-year-old. The order of suspension does not narrate any wrongdoing on the part of the petitioner. The power of suspension is exercisable under Rule 10, so and so. Then, my lord, directed to reinstate. State the order. Para 5, my lord, page 140. The order of suspension does not reflect any ground enumerated above. The allegation is that petitioner has been erroneously selected. If that be the case, and in the absence of any allegation of wrongdoing,
Yes.
pursuant to this order, my lord, not the respondent implemented the order, reinstated the petitioner on 9/6/2023.
Yes.
Again, my lord, on 4/7/2023, after reinstatement, petitioner was placed under suspension for the second time. For the second time.
Why? What is the charge?
In respect of the same incident, Lord, one additional factor would be charge sheet is filed. Charge sheet is filed against the petitioner. Lord, incident is same, but Lord, the first suspension order does not indicate the filing of charge sheet and arrest of the petitioner.
Arrest happened.
Arrest of the petitioner. Lord, articles of charge in respect of this incident was issued on 20/11/2023. Enquiry officer is appointed on 15/3/2024.
Yes.
My lord, before that, my lord, FIR was registered not against the petitioner. FIR was registered on 12/8/2022 against Mahesh Susuladi. In that, my lord, investigation in respect of that crime, petitioner was also arrested. Petitioner,
Not made an accused.
please, my lord.
You were not made an accused.
In the FIR, I was not the accused, but in the charge sheet, my lord, charge sheet is filed on 24/11/2023.
When was the arrest?
Not the arrest is
It was detained between 3/7/2023 to 14/7/2023.
3/7 to 14.
Yes.
Yes. Not charge sheet is filed on 24/11/2023.
Yes.
Not challenging the order of suspension. Not I approached the Honorable Tribunal. The suspension order is dated 4/7/2023. Impugned order of suspension dated 4/7/2023 was
Yes.
challenged. Lord, the tribunal passes an order that, my lord, my application is allowed.
Hmm.
My lord, in the connected matter, I'm sorry, my lord, in the connected matter, which is listed before my lords. In this case, my lord, application is dismissed. Para 6 is the, my lord, finding at page 54.
Yes.
Perusing the materials, it is no doubt true. Earlier also, this applicant filed application number so and so challenging the order of suspension. As this tribunal has not granted interim order of stay of the suspension, same was assailed before the Honorable High Court in writ petition number so and so. And Honorable High Court was pleased to grant an interim order of stay of the order of suspension dated so and so, and subsequently the said writ petition was also disposed of as per the Annexure A9. That is, my lord, order my lords have seen. Then, my lord, para 7. Regarding the case against the applicant,
Therefore, the tribunal dismissed application number 20.
since, my lord, I have been reinstated. Pursuant to the interim order, I was reinstated on, my lord, 9/6/2023.
Regarding the case as against.
Yes,
the
on merits, my lord, para 7.
applicant, merits were discussed in the said order while
It-
dismissing
It
application.
is not the contention of the applicant hearing that this order dated 23/8/2023 passed in application number has been challenged before the higher forum and it is set aside. When that is so, order of this tribunal dated so and so attains finality. Apart from that, now coming to the present application of suspension order dated 4/7/2023 came to be challenged. The grounds in the application goes to show that when the High Court or Honorable High Court has already allowed the application considering the earlier suspension order, there is no question of again passing the suspension order against the applicant herein by order dated 4/7/2023. But looking into the material, reasons mentioned by the respondent authorities for keeping the applicant under suspension again on 4/7/2023 order is because on 3/7/2023 applicant was arrested by the CID police in connection with registration of crime 55 of 2022, wherein this applicant was arraigned as accused number 29 and it was registered for the offences under section so and so. It is also the allegation against the applicant herein that he obtained the post by illegal means. While the dismissal order against this applicant on the earlier application number so and so similar allegations in application number so and so, all those batch of applications were also dismissed by this tribunal. The said dismissal order of the tribunal, some of the applicants therein have approached the Honorable High Court, so and so, and division bench of the Honorable High Court disposed of the writ petition by its order dated so and so have been dismissed. The Honorable High Court of Karnataka, while disposing the writ petition, observed as under. Therefore, looking to the materials for quashing the suspension order challenged in this application, on the ground of arrest of CID of this applicant, and he was remanded to judicial custody, and the charge sheet is filed after the investigation in the matter, and additional charge sheet copy is produced by the applicant himself along with the application, and it is at Annexure A21. I have perused the additional charge sheet under Annexure A21 on running page number 164 of the file, wherein applicant has been mentioned as accused number 29, and offense for which he is said to have been committed the offense under section 120B, so and so. So this charge sheet is after finding that there is prima facie material collected against the applicant for involvement in the said alleged offense, as this tribunal once considered while dealing with the earlier suspension, but prima facie material ultimately dismissed the earlier application. One of the
Yes.
contention taken by the applicant
Yes. Yes.
in his application, his suspension order came to be passed after a long gap of a decade. Therefore, initiation by delay of 10 years is contended. Then, my lord, tribunal says ultimately, my lord, at page 62, para 9,
Hmm.
that, my lord, articles of charge is issued, and therefore my application is dismissed. Lord, assuming for a moment, my lord, inquiry is initiated now. Lord, after my appointment is in the year 10 years ago. Therefore, my lord, at this stage, I will, Lord,
What happens to the suspension orders in respect of all identically situated persons?
Lord,
It appears it is not one case, because the additional list persons.
Lord,
include the additional
it is
list.
in respect of the old suspension. For the present suspension, my lord, these are the only two.
No, if as a matter of fact,
Yes,
all the other persons who suffered suspension identically with you, all their applications have been dismissed and this court has upheld
Yes,
also. And there is a criminal case pending. and-
criminal case pending. Yes, Lord, criminal case is pending. What I would say, my lord,
The criminal case, the chance of proving all these allegations, 120B, 420, 34 IPC, may be difficult, but in.
in the
if a-
departmental inquiry.
Departmental
Lord,
inquiry-
I would say, Lord, but let them reinstate, not hold a departmental inquiry. It is a, not admittedly 10 years old incident.
Now the statement of, I mean, articles of charge have been issued
Inquiry officer is appointed.
in 324. What happens after
Discovered
that?
only in 22, man. FIR was lodged only in 20.
Yes, my learned friend is right.
And
My lord, now the
charge-
second suspension is a deemed suspension under sub-rule 2 of Rule 10 of the CCA rules. But in
Lord,
fact,
even,
I just draw
I'm
your
sorry, my
lordship's
lord.
attention to some of the annexures that the state produced when they filed the written reply statement before the tribunal. Your lordships may kindly come to paragraph page. Lord, Lord, no translation is provided. This is the classification of the posts. He has been selected Lord, under 3A others, my lord. If your lordships will notice at annexure R3, page 275,
Hmm.
under 3A, the first table, my lord, because it is PCM Kannada. Under 3A is in one.
These are the merits of the matter. We have no, there is, it has to be decided in the proceedings. In the
So what I'm saying
proceedings.
is, in the suspension
good-
order, these things have been taken into consideration. In fact, the order by which by the notification by which he is appointed, he is appointed against 3A rural. There is no post available in the notification for that particular category at all. He has been selected, and also the marks your lordships will be easily able to notice. He has been, it is shown that he has secured 68 marks. Whereas in annexure A2, which is in English, my lord, page 274, it is stated while rejecting his candidature, which is in the official records at page 274, it says it is 61.22 marks. So it is not as though he was not aware when he got the appointment order that his marks have been shown to be more than what it was actually.
No,
So it's not as though he was not even aware.
who is the charge against?
My lord.
Is it against the selecting authority or is it against somebody else who has?
Action has been taken against all of them, including the joint directors from whom the letters have been sent for making the appointments. In fact, it has originated from the office of the joint
Please
director.
tell us what happened to the others who had been suspended. There were others involved as
They have
well.
not challenged.
Not challenged.
They are not challenged. They are probably awaiting for the outcome of this case.
They are, but they are.
My lord, the government as a model employer not only has a duty to treat the employees fairly and in a non-arbitrary manner, it also has a duty to maintain a clean image. When the image of the employees are prima facie tainted, my lord, it is very clearly, I mean, this was brought in the, it was published in the newspaper also. Thereafter, the investigation started, and it was discovered that they have been appointed by additional lists which have been announced more than 6 months after the final list was announced. And the government, there is a circular prohibiting announcement of additional list after 6 months. And also it is clear that he has been given 68 marks.
It was 1 year.
68 marks.
Who was the selecting authority? Just only for information, not otherwise. Who was the selecting authority?
Joint
The
director.
Public Service Commission,
Joint director.
thankfully.
It has happened at
But
the,
I am
my
not
lord, the
saying
whole
that not
process
they have
was
stopped.
computerized. And these things could not have happened. Actually, they have come from, the entire selection process is automated, my lord. From the stage of processing the applications to the stage of correcting the ORM sheets, the answer sheets in the competitive exam, everything is computerized.
Absolutely shocking to say the least. This being manufactured after the final list.
4 joint directors have been,
But it is not.
action has been taken against 4 joint directors.
State government.
Exactly.
And he knows that the marks given to him is more than what should
being
have been given.
manufactured here, not on you as a person or alone. You can also, you cannot escape from the complicity in this entire thing. Somebody creates a list after the time lapses. The list is appended and then appointments are made from the list. Even the mark in the list is apparently incorrect.
What I am
Well, ultimately, whether this will end in a conviction or not is anybody's guess. But at least
it may not.
it may not. This is the,
But it will take.
Lord,
not
even if it
so-
doesn't, they cannot be continued in service because they have not been selected in accordance with law. Clearly, they are the beneficiaries of an illegality, my lord. They cannot be continued at all. It taints the image of the government also if they are continued in service. And they are teachers. The
There is
post
no
is that of a
second-
teacher.
there is no second suspension in respect of the others. Their first suspension, they had challenged. That was rejected. They had also come before this court. All writ petitions dismissed. That is the situation. Only one got the benefit of that judgment of this court.
That is the petitioner.
That
We
the
were
reason for
being-
the second suspension is completely different because it was of the arrest. So the what happened prior may not be relevant at all for the second suspension case.
Incident is in respect of the very same allegation.
That may be,
The
Yes.
incident is the same.
that may be, but there is
But-
something in
but-
between.
But I.
Which is the order of suspension, the present
Next
suspension?
11.
Present suspension is at page 145.
Is there a translation?
Translation is not available.
Station,
But in addition to the arrest, the detention in custody, they've also narrated the entire, they've applied their mind to the entire set of
Please
facts.
read it out from,
But I
Yes.
tried to translate it, but the, not,
no, reading by itself may be sufficient. I'm able to follow basically. There are words that I cannot follow, but
yes,
the general idea I can.
up to serial number 147, Lord, I can read, my lord.
Hmm.
But these are the, Lord, narration of facts which
Hmm.
we have narrated to my lords.
Hmm.
Will give context if you read. It will give context if you read.
No,
It will be helpful, man, going through the.
My lords,
it's just because for
May I read?
deciding either way,
Yes.
we must have
yes,
the material. This is the basic material.
yes, page 146.
The order of suspension we need to have.
Yes, page 146. I'll read.
Yes,
But if translation required, my lord, I'll do.
I think it is better. Is it not? Can you read, please?
Please.
Hmm.
Renuka K.
Hmm.
But the name portrays that not female.
Yes,
not,
it's a
she's
male. Yes. Yes, I figured out because it is son of. Yes.
ರೇಣುಕಾ ಕೆ PCM ಕನ್ನಡ ವಿಷಯದಲ್ಲಿ ಆಯ್ಕೆಯನ್ನು ಬಯಸಿ ಆನ್ಲೈನ್ ನಲ್ಲಿ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಸೋನ್ಸು ಅರ್ಜಿಯನ್ನ ಸಲ್ಲಿಸಿ ಸ್ಪರ್ಧಾತ್ಮಕ ಪರೀಕ್ಷೆಗೆ ಬೆಂಗಳೂರು ಉತ್ತರ ಜಿಲ್ಲೆಯಲ್ಲಿ ಆಯ್ಕೆಯನ್ನು ಬಯಸಿ ಪರೀಕ್ಷೆಗೆ ಹಾಜರಾಗಿರುತ್ತಾರೆ. ಶ್ರೀ ರೇಣುಕಾ ಕೆ who has applied for selection to the post of PCM Kannada participated in the selection process in Bangalore North District and appeared for the examination. 2012-13 ಸಾಲಿನ ಬೆಂಗಳೂರು ವಿಭಾಗದ 3A OT ವರ್ಗಕ್ಕೆ ಹುದ್ದೆಗಳ ವರ್ಗೀಕರಣ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಮುಖ್ಯ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಮತ್ತು ನಿರೀಕ್ಷಣಾ ಆಯ್ಕೆ ಕಟ್ ಆಫ್ ಪರ್ಸೆಂಟೇಜ್ ಇರುವುದಿಲ್ಲ. ಆದಾಗ್ಯೂ ಸಹ ಸದರಿಯವರು ಸ್ಪರ್ಧಾತ್ಮಕ ಪರೀಕ್ಷೆಗೆ ಹಾಜರಾಗಿ 61.22% ಗಳಿಸಿರುತ್ತಾರೆ.
No, like you said, those are the narrations. Can we go to page number 148 and
Yes.
and
that is
after serial number 16 would probably
Yes,
be the
that is
relevant. Yes, you
These are
please.
all narration of facts.
Yes.
ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಮಧ್ಯಂತರ ತೀರ್ಪಿನನ್ವಯ ಶ್ರೀ ರೇಣುಕಾ ಕೆ ಸಹಶಿಕ್ಷಕರು PCM ಕನ್ನಡ ಸರ್ಕಾರಿ ಪ್ರೌಢಶಾಲೆ ತಿಗರ ಹೊಸಹಳ್ಳಿ ಕನಕಪುರ ತಾಲೂಕು ರಾಮನಗರ ಜಿಲ್ಲೆ ಇವರ ಮೇಲಿನ ವಿಚಾರಣೆ ಕಾಯ್ದಿರಿಸಿ ತಕ್ಷಣದ ಜಾರಿಗೆ ಬರುವಂತೆ ಅಮಾನತನ್ನು ತೆರವುಗೊಳಿಸಲಾಗಿತ್ತು. In view of the decision of the Honorable High Court,
He was reinstated and working at.
he was reinstated.
He was reinstated and.
He was reinstated pending departmental inquiry.
Correct, correct.
ಆದರೆ ನೀವು 2012-13 ಸಾಲಿನ ಬೆಂಗಳೂರು ವಿಭಾಗದ ಪ್ರೌಢಶಾಲಾ ಸಹಶಿಕ್ಷಕರ ನೇಮಕಾತಿಯಲ್ಲಿ ನಿಗದಿಪಡಿಸಿದ ಕಟ್ ಆಫ್ ಗಿಂತ ಪರ್ಸೆಂಟೇಜ್ ಗಿಂತ ಕಡಿಮೆ ಅಂಕ ಪಡೆದಿದ್ದರೂ ಹುದ್ದೆಗಳ ವರ್ಗೀಕರಣ ಇಲ್ಲದಿದ್ದರೂ ಸಹ ಅಕ್ರಮವಾಗಿ ನೇಮಕಾತಿ ಹೊಂದಿದ್ದರ ಮೇಲೆಗೆ 17/5/2020 ಅಮಾನತುಗೊಳಿಸಲಾಗಿತ್ತು. Notwithstanding the High Court's order, you were kept under suspension on 17/5/2023 on the ground that you have secured marks which is less than the cutoff percentage and there was no classification, there was no post against which you had claimed reservation.
Yes.
ಸದರಿ ಅಮಾನತಿನ ಆದೇಶವನ್ನ ಮಾನ್ಯ KATಯಲ್ಲಿ ಪ್ರಶ್ನಿಸಿ ತಡೆಯಾಜ್ಞೆ ದೊರಕದ ಕಾರಣ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ 10576/2023 ದಾಖಲಿಸಿ ದಿನಾಂಕ 31/5/2023 ತೀರ್ಪಿನಲ್ಲಿ ಈ ಕಚೇರಿಯ ಅಮಾನತಿನ ಆದೇಶಕ್ಕೆ ತಡೆಯಾಜ್ಞೆ ನೀಡಿರುತ್ತದೆ. You had questioned the order of suspension before the KAT. Honorable KAT did not grant interim order. Against that, you have preferred writ petition before the Honorable High Court in 10576/2023, wherein the Honorable High Court granted interim order. ಅದರನ್ವಯ ದಿನಾಂಕ 9/6/2023 ಇವರ ಮೇಲಿನ ವಿಚಾರಣೆ ಕಾಯ್ದಿರಿಸಿ ಇವರನ್ನು ಸೇವೆಯ ಮೇಲೆ ಪುನರ್ ಸ್ಥಾಪಿಸಲಾಗಿತ್ತು. Pursuant to the interim order, I have been reinstated.
Yes.
Then, Lord, ಇದು ರಾಜ್ಯ ವ್ಯಾಪಿ ವಿಷಯವಾಗಿರುತ್ತದೆ. I am sorry, Lord, one line is ನೇಮಕಾತಿ ಅಕ್ರಮಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ತನಿಖೆ ನಡೆಯುತ್ತಿದೆ. In respect of selection, matter is being investigated. ಇದು ರಾಜ್ಯ the present subject matter is pertaining to the entire state.
Yes.
And the petitioner was arrested on 3/7/2023 by CID. And investigation is still pending.
Yes.
Then, my lord, since the petitioner is not entitled for selection itself. And prime CID has registered the case and arrested. Hence, you are liable to be placed under suspension. Hence, the following order. But ultimately, my lord, the basis is the one incident, and my lord, additional factor is arrest. My lord, I myself, my lord,
Correct.
is the arrest. Ultimate, it revolves around the very same incident, which was subject matter of earlier suspension. And additional factor.
But
my lord,
as at that point in time, there was no arrest. Later, the FIR has been registered, you have been implicated and you have been arrested. You are accused number 29 now. You've been arrested, charge sheet is filed.
yes,
Matter is filed.
but charge sheet is filed, and I am attending the.
Yes, can we have a translated copy of this as well? The suspension order.
Let them reinstate, my lord, I'll.
What are they going to teach the students, my lord?
Yes. Yes, we'll have this next week. Please make available the translation. The Learned Counsel for the petitioner shall make available a translated copy of the order of suspension dated 4/7/2020. Just after a week. Court officer, give a date, please. After a week.
Correct. 10 adjourned. 7. The case.
Suspension.
Yes.
Okay, you can action at least. Which I want to interpret.
Yes.
The order of suspension was passed very second. The relevant rules of the department, including the election rate to obtain the 40. In the last paper, page number 47. Rules of the department.
Yes.
Schedule 2, madam. Schedule 2.
Yes.
Serial number 1 and 2. The appointing authority, the commission. And both the commissioner and the above authority, the state board. Very same line. KV itself is passed in order. What's the suspension? The last gets it at 18 number 11 page starts at page number 25. And very same issue. Para 7. No longer before the tribunal itself. Number 7.
Yes.
Mary.
Yes.
Page your last gets it at page number 25. Pair number 7. In the pair number 7, consolidated of pair number 7. After perusing of the material, one of the contention taken by the applicant in this application which goes to the very root of the matter is the person, authority who passed the suspension order is not competent to pass the order of suspension. Suspension order. Therefore, on that ground itself, the suspension order is not sustainable and it has to be quashed. This is where the notification issued by the government of the dated copy of the which is looking for the date of suspension order in 15%, looking to the same notification in the page number 3 of the serial number 4, which is mentioned in the insert or new schedule of serial number 2, which has been read out to you. Very when category of the group authority of the 4. Also mentioned as column number 4. Looking to this serial number 4 or insert page number 4, page 4, number 4 in column number 2, it is mentioned as Panchayat Development Officer. And column number 2 Commissioner, Panchayat Raj Commissioner, who is the appointing authority, and the header of the report is mentioned as state header. Therefore, the appointing authority is the Commissioner, Panchayat Raj, but the looking suspension order is issued by the executive agent, the chief executive officer, and the disciplinary authority during the ground. So that this has been affected in the case, it is a state will award the application, why the suspension order? Very same matter. Well, first takes the page number, suspension order. Page number,
You are now on a interim order.
interim order not granted by the.
It has to be considered whether this, is there any other reason why it,
They want to file a reply for this.
they have filed?
They have to file a request.
Yes, they have to file the reply statement. So only an interim order of suspension, interim order refusing to grant a stay of suspension. Take it up before the authority. Please, there is classification control appeal.
Even in the case, suspension order, rule 10 of the KCC rules provides for the person who asks for suspension and not complete that. So then a very simple rule 10. Rule 10 of the suspension.
Mm,
10.
mm,
Maybe, you know,
mm.
the appointing authority or any authority to which it is subordinate or any other authority empowered by the government in this behalf of state government under suspension. In reference to go back to appointing authority, any other authority, oppose the appointing authority, which is the government in my case, not within the authority, first the suspension order for the C was set up for the below, it's the appointing authority. So in section 10 also, with 10 of the KCC rules also.
Provided that where the order of suspension is made by an authority empowered by the government in this behalf, which is lower than the appointing authority, such authority shall forthwith report to the appointing authority the circumstances in which the order was made. So there is,
Rule 10, rule 10.
there is a provision. Yes, this is Rule 10 proviso. Provided that where an order of suspension is made by an authority empowered by the government in this behalf, which is lower. Exactly, council, which is why we are saying
has to-
there,
But
the
even now I
reason
have to
why
file a
it
reply.
has been done and whether there is any empowering provision is the matter which has to be considered by the tribunal now. When did you file your OA application?
Application which I filed before the tribunal.
Hmm. Hmm. What are the charges against you?
Well, start against me, there was a TV, there was publication of the TV, recordingly, TV. Based on the TV report, I've been kept under suspension. There's
It's
no-
not, it is not any
No,
prevention of corrupt, not
nothing,
PC.
nothing. Your artist can take the suspension order itself, they're reading of the suspension order.
Hmm.
There is no nothing reference, but only solely based on the TV channel report, I've been kept under suspension. And very same line, this honorable court has passed the interim order. And the division bench of this honorable court passed the interim order. Your artist.
Proviso to Rule 10(5). Chief Executive Officers of Jilla Panchayats are delegated the power to place under suspension a member of state civil services belonging to Group C and Group D. PDO comes under?
Group B, Group B.
Video is
B.
group B. Now it is group B.
A member of this state civil services belonging to Group C and Group D of any department other than Karnataka judicial.
And very same issue, the tribunal has allowed the application, which has been read out to the lordship. Please say, in that matter also, CU has passed the order, please. say-
When was that?
Your lordship passed on, judgment was passed on 14th. 2020.
Exactly, it is a judgment council. That is the difference. Let them place it on
Even
record.
here I have
If
to
as a matter
file
of
my
fact,
reply.
it is by an incompetent authority, it goes from the inception. Exactly, therefore, the fact that you have not been granted an interim order by itself, because if it is an incompetent order, it must go from its inception. So let them file their statement in every case where orders are granted or not granted. If you start coming up before the High Court, there must be some space for the authority also to, the tribunal to function. Instead of coming here, when is it posted before the tribunal next?
4/9.
It's almost here. Yes,
Lord,
Instead
even
of.
here I have to get instructions and make my submission.
So they
Even
have
there,
to
the
get
government
instructions.
says some officer has to give
Wherever
instructions
it
to the
is,
government to do.
they have, there has to be an opportunity to given to them to get instructions, whether there is any change in the situation. We don't know.
You could have sought an early date in the tribunal
Exactly.
itself.
All you need to do is seek an early date there in the light of this.
What my letter, my entry not a medical, sir. They did not get them to what they said, they want to file a witness statement, they won't file a witness statement.
Which is why we are saying that if, as a matter of fact, what you're saying is correct, there is no exempting circumstances, the order has to go from its inception. Therefore, it is a question of competence. It will go. How will you be affected by this? Suspension is a removal?
No, it's suspended, no.
Yes, the suspension, if what you're saying is correct, the suspension itself would go. Seek an early hearing there. We cannot assume the power of the tribunal and grant or not grant interim orders. Those are matters for the tribunal to consider. Probably this was not brought to the notice. How do we do? This judgment, was it brought to the notice of the tribunal?
Because very same bench for copy.
We'll say that you can seek an early consideration, bringing this to the notice of the tribunal. The government advocate will also get a chance to place his statements on record there, whatever objections there are, for whatever they were. Probably, if there is nothing, that is the end of the matter, it has to go.
What means?
Why don't you move for it?
But is there a date or given? Date was given on 4/9.
You cannot move for an earlier hearing. You're doing so here. In every case, where you need an earlier posting, you're making a submission to is being posted. This petition is filed complaining of non-grant of interim order in an application filed challenging an order of suspension. It is submitted that the order of suspension was passed on
On 13th.
on 13/8/2024 by the CEO of the Zilla Panchayat. Full stop. It is submitted that the petitioner here is a PDO, which is a Group B post, and that the CEO of the Zilla Panchayat has absolutely no competence or jurisdiction to pass an order of suspension as against a Group B officer. Full stop. It is submitted that though this matter was specifically brought to the attention of the tribunal, no interim order was granted by the tribunal. The learned counsel would also place reliance on a judgment of the tribunal in application number application number 16787. I'm sorry, 1895 of 2024, and contains that on the very same facts, the tribunal has quashed orders of suspension passed as against Panchayat development officers on the ground that the CEO of the Zilla Panchayat has no jurisdiction to pass an order of suspension. Full stop. It is submitted that the matter now stands posted to 4/9/2020 for the objections of the government advocate. Having considered the contentions advanced and in view of the fact that what is complained of, what is impugned before us is the refusal to grant an interim order by the tribunal. We are of the opinion that these are matters which have to be brought to the attention of the tribunal, and a request for an early hearing of the matter can be made by the petitioner. in the above view of the matter, this petitioner is disposed of, directing that in case the petitioner makes a request for an early hearing, the same shall be appropriately considered, and orders passed taking note of the contentions of the petitioner as well as the provisions of the classification control appeal rules and the, what was the material that you relied on? 13.3.
Rule 10 of cases should under another one, C and R rules of the department.
As well as the C&R rules of the department, and taking note of the judgments of the tribunal as well. If you move it, it will be taken up and without undue delay.
I will move it.
They have to be given some breathing time, whatever be the,
What are supposed to do? In this integral. Become know that there are even if it's succeeded before it. That's why I'm- for the-
yes, because if we ask the learned garden pleader to get instructions, that will also take time. Instead of that, if the primary authority considers within a reasonable time, it's all that is required. We shouldn't be interfering in the functioning of the tribunal to such extent. That is not the meaning of judicial review. Yes,
Hearing on IS, number 12, Mohan
Yep.
PS.
Appear for the appellant's counsel, my lords. In this
Yes.
matter, there is a delay of 150 days in filing the recalling application. Writ
Yes.
appeal was dismissed for non-prosecution, my lords. Office objections were not complied in time. Therefore, the writ appeal came to be dismissed. After that, we filed a recall application for which a 150 days delay has occurred, my lords. The
There,
appellant was
in
not.
the recall application, there is
Please.
an endorsement, an order minuted by this court. Pending
Please.
consideration of IA number 1 of 2023 and 2 of 2023, office objections as notified by the registry be removed before the next hearing date. I'm told that those office objections till now have not been removed.
My lords will comply, my lords. In a week's time, we'll comply.
In view of the noting by the registry that the office objections have not been complied with, 1 week's further time is granted
Please,
as a
my
last
lords.
chance.
Please, my lords, we will
Complying with
comply.
the office objections.
Please.
Last chance, please, otherwise the IAs will also stand dismissed.
No, my lords, we'll comply to much of.
Yes.
13, government advocate.
This matter was ready because last time about 15 days back, this matter was posted. Development took time for specific date. Submit my address.
Lords, this what happened is Physical Disability Act was in prevalence as of 2004 when the KPSC invited applications for. We had not provided the statutory 3% reservation for the physically disabled persons. So many people went under challenge with regard to the 3% reservation as such. KAT took it up as a, KAT issued around 18 general directions. We went into, we challenged the same. We were not successful as such. So what happened is the petitioner herein, a supernumerary post was created and he was accommodated in a group B post. But with regard to group A post, now we seek.
Petition, if he allows, I will I will say, make my statement.
It
10
is,
minutes.
It is the state's petition
the
is what.
state's petition.
Yes, sir.
It is a state's petition.
Statement. That's it.
So my lords, what happens is in group B post, we accommodated him by manner of supernumerary creation of post as such. After acceptance of the same, he wants a retrospective promotion to a group A post, wherein if we take the 3% reservation, we are unable to accommodate him. On a prior date to him as such, a person had approached the honorable court and his representation was to be considered, and with the available vacancy of reservation, we accommodated the said person in a group A post as such. So as of now, there is no vacancy with regard to the 3% reservation because the posts are already been filled. Now seeking the issue of parity, now the petitioner also wants to be accommodated in the post of group A. So what the KAT has directed is to positively consider his representation and take him to the group A post. So that's the issue involved as such.
Yes.
The petitioner hearing,
Yes.
As my learned friend pointed out, it is not 17, 18 people. Only 3 people approached the Honorable Karnataka State Administrative.
I never told 17, 18 people, let words not be put into the mouth, my lords.
Yes, what is the post in question?
The
Excuse me, counsel, what is the post in question?
post in question is presently the petition, the respondent.
Post in questions were both group.
Recruitment was for both group A and group B. The tribunal, instead of squashing the entire selection.
It was a special recruitment?
No, it is
It was a normal.
Under the physically disabled quota was not provided as required under the Disability Act. Therefore, this tribunal, instead of squashing the entire selection process, directed that the petition, the applicant before the tribunal be granted the selection appointment to the court. It was not with reference to any merit list. It is only because physically disabled people were not given reservation for over a period of time from 2005. Then not page number 213 election given. It's the first in the series of the order from which the entire the process, the present proceedings arise. The article 10 is page number 200.
The matter is to be finally heard today? Is the matter to be finally heard today?
Instead
we
of
may not-
consideration of IA for interim stay, it has to be disposed. Any day convenient to the court will also be ready as such.
May not be today.
What has happened is out of the 3,
Hmm.
2 of them have already been given. Only I have not been given. I may letter friend that somebody came earlier, nothing like I approached the tribunal earlier. And I approached along with Mr. Vishwanath Kirela. And in the common order, both the applications were allowed, saying that these people should be given group A, not group B. But in respect of group Hiremat, because you are nearer to the then chief minister, orders were passed within a short time and he was given. He is also general merit, I am also general merit. It was not in presence of any merit as already stated, but it was on the basis of that. Comparatively, the only factor that could have been looked is the age. I am higher in age as compared to Hiremat. If they wanted to give a appointment between the two, it should have been me because I am senior, but I was not here at the government circles, therefore my appointment.
Is Vishwanath Hiremat a party to this writ
Yes,
petition?
along with me was the applicant.
Is he a party to this writ petition? He's not.
Because he has now been given.
Therefore, we cannot
Yes,
cast
yes.
aspersions against somebody who's not here on the party hearing. Therefore, let us forget that let us stick to the facts of the case. We cannot hear allegations against somebody who's not a party.
While implementing the order, he was given, I was not here. Then I approached the tribunal, that tribunal, because I was issued individual endorsement rejecting my claim. Tribunal allowed my application, if you are not just, which is the impugned order in present writ petition. If that order is read, then the entire facts will be clear. May you are watching the page number 41.
Council, the matter has to be heard finally. The piecemeal hearings may not be possible. We are at almost, we have.
But earliest date may not where he will not seek adjournment and mandate be heard.
He's not
I
seeking
am not
adjournment.
seeking any adjournment.
He's not seeking adjournment.
Everything is
because
been
we
put
have
into
a
the words of the
list.
government.
We have
That
only.
should not be the case of the,
We
the
have-
answering respondent as such. I have not even opened with regard to the seeking of time, my lords. From that time, I just said several persons, 17 to 18, for the seniority of the person at the bar. Such submissions is not, should not be, generally,
Please.
Saying that this matter may not be urgent because earlier I have suffered much.
Yes.
whatever dates
they may not
convenient
be
to the
able to
court, the
accommodate you
government
today.
will be
Yes.
ready, my lords.
10-9, number 14.
Next week.
It is not possible, council. There are too many matters being,
Top of the list are. Top of.
yes.
Wonderful.
14,
That's the matter that subtraction at the final. Petitioner, the daughter, this is married daughter. The father of the petitioner died.
7/9/2019, my lords.
There was compassionate appointment on. The request for compassionate appointment was rejected as per section A7 on the ground that I am married daughter. Therefore, it can't be given. That endorsement is dated 10/12/2019.
Yes.
7/9/2018.
Application,
The request for 10/12/19.
application was,
Translation.
date of application?
The mother primarily gives consent on 6/11/2019. The only reason why it went against them is one ground might not survive, my lords, because the divorce was taken post the demise. That is no longer available because of the amendment made, and my lordship's holding that married daughter is entitled retrospectively. The second submission is, though 7/9/2019 date of demise, 6/11/2019, the mother gives consent in favor of the petitioner hearing for appointment. But the application in the prescribed form has been filed post 1 year is the surviving legal point for this honorable court as such.
No, when was the application made, please?
Application on behalf of the applicant, mother made in 6/11/2019. And that after that rejection was also made. The respondent rejected my case, not on the ground that application was not.
When was the application made, counsel? We are making a,
It was rejected on 10/12/19.
when was it made?
Thereafter, another, I approached the tribunal, filed the application 6/40/2020. I approached the tribunal challenging the endorsement in which they rejected my case on the ground that I am a married daughter, I am not eligible. That order may not mention 8/3/2020. I am saying that before I submitted my application on my own, there was a proceeding before the tribunal. Tribunal may not, as per its order, mention 8 page 21. There is said that the case of the applicant, page number 69 or A8. 69, the tribunal, after finding the endorsement in the circumstances, has made a strong case for interference with the impugned order. Accordingly, allow this application and require the impugned order 10/12/2019, in which it was said the married daughter is not eligible. The third response is directed to consider the application submitted for strictly in accordance with the rule. This order was made in March 21. Thereafter, one more representation was given on 15/3/2021, which is page number 72. Because after the tribunal directed on 3/3/2021, rejecting the endorsement of the government saying that married daughters are not eligible, then one more representation as per A9 was given by the applicant herself. That was given on 15/3/2020. Whereas in the earlier proceedings, no such thing was raised. In second endorsement after the tribunal order, now they say that the applicant application is in 2021, therefore it cannot be considered. Whereas it's an offshoot of the earlier order of the tribunal, because matter was before the tribunal when my request for appointment was rejected. That is said by on my behalf by my mother, was rejected on the ground that I was a married daughter. The matter went to the court and tribunal in 6/40/2020, and it says A8 page 69. Directed that the case of the application shall be considered. Then one more representation, not 8/9 was given. Now they take that as the basis and say, you have made up the representation only in March 21, overlooking all the earlier proceedings of the tribunal, where they themselves had rejected, when they had requested to reject the application made by my mother, saying that you are married daughter, you are not eligible. Where the question of myself was submitting the representation, because I approached the tribunal within that period in 20 minutes, 6/40/2020 is my application. Before the tribunal in the reply statement also, they did not contend that application is not fair, therefore it is rejected. They said they tried to contend that I am married daughter, therefore I am not eligible. But when I gave the order, in pursuit of the tribunal order, I gave detailed pro forma application along with the order of the KIT. Now they come up with the reason that this application which now gave the pursuit of the tribunal order is not within time. This is the respondent trying to find out some reason to deny the appointment, compassionate appointment. Because if this was the case that application was not made, that should have been the reason when I approached the tribunal itself in 2020. which was within 1 year limitation, that was seized by the tribunal. And the question of whether a married daughter is not, was this a subject matter? When the entire matter was pending, legal question was pending. How could there be a question? Soon after the order was passed and the court said that married daughter is eligible and the endorsement is wrong. And I submitted the second representation on my own, whereas my mother's representation was very within 1 year. My representation in pursuance of the order of the tribunal was included.
Yes.
Therefore, now what was challenged before the tribunal was that the endorsement which was subsequently issued, which says that that is on July 22, next year, 12 and 13, was an endorsement issued to the applicant in pursuance of the order of the tribunal, where they come out with a statement that application is given after 1 year. That is one reason. Another is once again saying that amendment has come subsequently, whereas the law has been laid down as per annexure A, judgment of the tribunal itself is here, page number 44, annexure A1. As early as in 2017, by a tribunal order, which was declared that married daughter is also eligible following the High Court judgment and other references, page number 59. The tribunal has held that the married daughter is entitled for compassionate appointment. Law was already declared. This was not subject matter of any challenge. Annexure A1. In spite of that, endorsement was issued that married daughter was not eligible. That endorsement was in 90. I approached the court in 2020. This annexure A1, page 44, in the case of one Vetra, she was also denied the appointment on the ground that she was a married daughter. After referring to the law and the constitutional president, tribunal as early as in 2017 declared the law that compared to the married daughter is eligible. Then to make an amendment, the tribunal did not say make a law, my lord. They said the law is bad in law, you have to give appointment to married daughter. No doubt subsequently they made a law saying that married daughter is also eligible. This is the legislature made law which they made subsequently. But the law declared by the court that married daughter is eligible was already there. Therefore, the earlier endorsement issued to my mother's representation that married daughter is not eligible was not proper. Tribunal rightly quashed it, then directed reconsideration. Then one more application they have given. Therefore, they cannot take this as an advantage to deny the appointment to the applicant because it is their own doing. They earlier said totally go outside the scope of appointment. They prevented me from.
Yes.
My lords, with regard to the married daughter, it is unsustainable because my lordships have further held that it is retrospective in nature. So the list is settled, my lords. We have no issues at such. 7/9/2019, date of demise, my lords. 6/11/2019, within the period, the mother gives the representation. We also act on the representation as on 10/12/2019, but we do not say that it is in the prescribed form as such. So this endorsement, even if we had said the same, this was challenged and it was set aside in application number 640 of 2020 as on 3rd March 2021, my lords. Then diligently on 15th March 2021, application was made by the petitioner for in pursuance of the directions of the tribunal as such, my lords. So even that ground with regard to the delay might not survive. I have to concede on this one.
Did not survive.
That's the reason I took to the dates once again, my lords, because the first round, everything was concluded between September to December, including our endorsement as such. So there was an adjudication on the endorsement also within time. So post the adjudication of the endorsement, there was a direction by the judicial authority for her to apply and for us to consider. So our consideration was twofold. One, that she is being a married daughter, which ground is no longer available to us. With regard to the later date of preferring of the application post 1 year, it is because of the judicial order in her favor as such. So that might not stand as my respectful.
What was your contention before the tribunal?
Tribunal only proceeded on the aspect of the divorce being granted
No,
and married daughter.
only-
But with regard to
Only with
this,
regard to your contention before the tribunal. What was the contention you had taken before the tribunal?
I'll just
Only to
take
record
my-
your
very much,
objection.
my lord. So I'll page 14 to 31, my lord. So Para 3 at page, ink page 20, my lords. May I go through the same?
Yes.
The respondents' governments filed the reply statement containing that the applicant Srimati Megashri is a married daughter of the deceased government servant Sri V. Nataraju, was working as a follower in carp-mounted company Mysuru and died on 7/9/2019. The wife of the deceased government servant Srimati V. Rohini submitted a representation to this office on 6/11/2019 seeking compassionate ground appointment towards second daughter Srimati Megashri. As Srimati Megashri is a married daughter of the deceased government servant, and she is not eligible for compassionate ground appointment as per government notification dated 12/9/96. Hence, an endorsement issued from the respondent's office dated 10/12/2019. The endorsement was challenged by the applicant in the Honorable Case at 640 in application number 640 of 2020, and the order dated 3rd of March 2021 allowed the application and quashed the impugned order of third respondent dated 10/12/2019 as per Annexure A7. The third respondent is directed to consider the application of the applicant submitted for compassionate appointment strictly in accordance with the rules if she is otherwise eligible under the rules. As the applicant has submitted the application on 22/7/2021, same is Annexure A1 for compassionate ground appointment. The application has not submitted the application within 1 year from date of death of the deceased government servant, and she was not eligible for compassionate ground appointment as per government notification dated such and such. The copy of the government notification dated 12/9/96 is Annexure R2. Hence, an endorsement was issued which is dated 3/8/2022. The applicant Srimati Megashri is a married daughter of the deceased government servant. Sri V. Nataraju was working as follower in such and such thing. Married daughter of the deceased government servant is not eligible for compassionate appointment as per government notification dated 12/9/96. Sri V. Nataraju was working as follower in carp-mounted company Mysuru and died on 7/9/2019. The wife of the deceased government servant Srimati V. Rohini submitted a representation to respondent's office on 6/11/2019 seeking compassionate ground appointment to her second daughter Srimati Megashri. As Srimati Megashri is a married daughter of the deceased government servant and she is not eligible for compassionate ground appointment as per government notification dated such and such. As Srimati Megashri is a married daughter of the deceased government servant and she is not eligible for compassionate ground appointment as per government notification dated such and such. Hence, an endorsement issued from respondent's office dated 10/12/2019. Honorable KSAT in application number such and such order dated. So everything went on the issue of married daughter as such.
Yes. Is the petition is file seeking the following.
Finding to the effect that why the
First
delay in giving of the application is to be condoned, my lords, or
Yes. Heard the learned counsel for the petition is file seeking the following reliefs. Heard the learned counsel for the petitioner as well as the learned government advocate appearing for the respondents. It is submitted by the learned counsel for the petitioner that the petitioner is the daughter of V. Nataraju, who died in harness on 7/9/2019. Full stop. The petitioner's mother, that is the widow of the deceased government servant, had made an application on 6/11/2019 seeking compassionate appointment for the petitioner. However, the same was rejected by endorsement dated 10/12/2019 on the ground that the petitioner is a married daughter and that there is no provision in the rules of 1996 to grant appointment to a married daughter of a government servant dying in harness. The petitioner challenged the said endorsement before the tribunal, and by order dated 3/3/2021, the tribunal had allowed the application and had directed the reconsideration of the application for compassionate appointment. The third respondent was specifically directed to consider the application of the applicant submitted for compassionate appointment strictly in accordance with the rules, if she is otherwise eligible under the rules. It is submitted that an application in format was thereafter submitted on 22/7/2021. The application in format
Yes, my lords.
on 22/7/2021, which was again considered.
But before that, on 15 March 2021, of, as per the directions of the tribunal, representation was submitted. Thereafter, the application in the format was submitted.
It is submitted that, please omit the last sentence. It is submitted that on 15/3/2021, pursuant to the direction of the tribunal, the petitioner had submitted a detailed representation before the third respondent. Thereafter, on 22/7/2021, an application in proper format was again submitted by the petitioner. However, the said application was also rejected by annexure A13 endorsement dated 3/8/2022 on the ground that the petitioner's application was belated, as also that she was not entitled for compassionate appointment in accordance with the rules. Full stop. The said endorsement was again challenged before the tribunal. However, the tribunal found that the application made by the petitioner in format on 22/7/2021 was belated, since the date of death was 7/9/2019. Further, it was also found that though the rules had been amended on 9/4/2021, the said rules were prospective in operation and could not be applicable for considering the application submitted by the petitioner, since the date of death was 7/9/2008. The learned counsel for the petitioner submits that the position that a married daughter could not be denied appointment was well settled even prior to the death of the petitioner's father, and relies on annexure A judgment, annexure A order of the tribunal in application number 9763 of 2015, dated 27/10/2017, in support of the said contention. It is contended that, relying on several judgments of the apex court, the tribunal had clearly held that any provision denying appointment to married daughters, including Rule 3 of the Karnataka Civil Services Appointment on Compassionate Rules 1996, would be illegal and discriminatory. Full stop. It is further contended that this court in, which is that judgment, Bhuvaneshwari v. Puranik, and so and so, has also held that the provision in the rules which denies appointment to married daughters is bad in law and has struck down the said. Full stop. This court has also thereafter considered the effect of the striking down of the rules and has held in petition number 20216 of 2024 that even without the amendment to the rules by notification dated 9/4/2021, the striking down would be effective from the very inception of the rules, and that therefore the rules, the claim of married daughters would have to be considered without the question of prospective operation or retrospectivity of the amendment dated 9/4/2021 being considered. Full stop. It is therefore contended that the order of the tribunal, which declines the claim of the petitioner was per se wrong and illegal, full stop. The learned government advocate submits that a reply statement had been placed on record before the tribunal, specifically stating that the death being on 7/9/2019 and the amendment to the rules having taken effect only from 9/4/2021. The application submitted by the petitioner would have to be considered taking note of the date of death of the government servant, full stop. It is therefore contended that since the amendment dated 9/4/2021 had only prospective effect, the earlier application submitted by the petitioner could not have been considered. Submitted by the petitioner's mother could not have been considered, full stop. It was further contended before the tribunal that since the death of the petitioner's father was on 7/9/2019 and the application in due format was filed only on 22/7/2021. The same was belated and could not have been considered in terms of the provisions of the rules. Having considered the contentions advanced, we notice that the death of the petitioner's father was on 7/9/2019. The petitioner's mother had made an application for compassionate appointment for the petitioner on 6/11/2019. The said application had been rejected by Annexure A7 on 10/12/2019 on the ground that the petitioner was the married daughter of the government servant who died in harness. The petitioner had challenged the said endorsement before the tribunal in application number 640 of 2020. And by judgment dated 3/3/2021, the said endorsement was set aside and the application was directed to be considered without reference to the objection that the petitioner was a married daughter. Immediately thereafter, the petitioner submitted a further representation on 15/3/2021, pointing out the aspects of the matter and seeking a reconsideration of the application. An application in format was also preferred on 22/7/2021 by the petitioner. In the facts and circumstances as narrated above, we are of the opinion that the finding of the tribunal that the application in format dated 22/7/2021 was belated was erroneous in view of the fact that the tribunal itself had directed the consideration of the application of the petitioner without reference to the ground that she is a married daughter of the deceased government servant. In the above circumstances, we are of the opinion that the petitioner had thereafter challenged the endorsement dated 3/8/2022 before the tribunal. In the specific facts and circumstances of the instant case, we are of the opinion that the finding that the application in format dated 22/7/2021 was belated is not justified. Further, in view of the fact that this court in Bhuvaneshwari v. Puranik had specifically found that the provision in the 1996 rules to the effect that married daughters were not eligible to apply for compassionate appointment was bad in law and had struck down the same. The contention that the amendment to the rules dated 9/4/2021 was prospective would have no bearing on the legal situation, since the offending provision stood struck down by this court, which was upheld by the apex court as well. Full stop. In the above view of the matter, we are of the opinion that the finding of the tribunal to the effect that the petitioner's application dated 22/7/2021 could not be considered since the amendment dated 9/4/2021 had only prospective operation. Cannot be countenanced. The writ petition is therefore allowed. The order of the tribunal, which is under challenge, is set aside. The application preferred by the petitioner will stand allowed. There'll be a direction to the respondents to take up the application for compassionate appointment preferred by the petitioner and to consider and pass orders on the same without raising the objection that the petitioner is a married daughter of the government servant. All other aspects are left open to be decided in the application in accordance with. Time limit. The said application shall be considered on its merits as directed above within a period of 3 months from today.
Tata Shetty.
We'll have it on some other day. Retirement memo has to be accepted. Has to be accepted. Yes, the memo for retirement is accepted. Yes, list in the first week of.
9/9.
Yes. Till such time. Let us see. Yes.
Passed over matter.
16 and 17 are.
28.
Yes. Yes. No, it was contended that somebody else had said that there is another government, a circular which has been issued by the government, which is also under challenge before the tribunal, and that they are also filing a writ petition, which was why it has been listed to 27. 28. Correct, correct. That is under challenge. Correct, correct. Let them also come on record. Correct, correct. Hmm. Correct. Whether the separate petition is here or not, we'll consider all the aspects of the matter on that. 28th. No, that passed over matter.
Passed over matter. 6.
This is the suspension that you are.
Milords, in this matter,
Yes.
I just let my learned friend comment, just one submission. Milords.
Yes.
But in this matter, AG was appearing in this matter because the matter was sensitive for the state. Now, we have, I think last 2-3 dates, we have taken time, Milords, on that basis, and my learned friend is agreed because it's a suspension. And now, Milords, I've been asked, I'll be appearing in the matter because he is not able to come. He has requested me to appear.
Yes.
Milords, let him argue today, Milords. I may be permitted to reply on Tuesday, Milords. I have seen the papers, but just to get ready fully, Milords, because this there were separate rules. Apart from the regular CCA rules is not applicable to them. They have separate the police department.
Arguments, or shall we hear it on that day, on Tuesday? What is the issue? When were you suspended? On what ground? You were, what were you? Yes. Hmm. Hmm. Hmm.
Not on that basis.
Hmm. Hmm.
Either way,
Hmm.
the order of suspension is dated 15/10/2022. Order is passed by an in-charge officer.
Hmm. And are memo of charges issued?
That articles of charge were issued, that which I questioned it before the tribunal, handed me an interim order, rejected the application, which I filed before your honor, and your honor, granted me an interim order. It is on the ground that the inquiry officer has issued the articles of charge. But the state government has come up with a circular saying that all the charge members in the inquiry officer has issued the articles of charge will be withdrawn. State government has made a circular. But the so far as suspension is concerned, 15/10/2022 is suspension. Till today, no subsistence. No subsistence. It is an admitted case that more than 6 months has elapsed. The articles of charge have been issued on 5/4/2023.
Hmm. 5/4/2023 without. Yes. Hmm.
Therefore, my conclusion, there is no order extending the order of suspension.
If it is 15/10/22, then within the 6 months, the memo of charges is issued.
5/4/23.
5/4/23. It's within 6.
Within 6 months.
It's
But
within
even
6
if
months.
articles of charge is issued, then they have to be reason for extending my suspension.
If
All
the articles of charges are issued, is there a requirement for?
in
In fact,
the reason is that since articles of charge is already framed, witnesses are there, documents are available. There is no reason to continue me under suspension for specifically articles.
You were never implicated in the criminal proceedings. What exactly is the allegation?
First factor case various land they are taking. This is Yoda upon this Yoda. That the allegation I am expect from lawyer had involved with the complaint who was in somewhere related to the land and threatened
After the order, because courts will
but it is on that basis, my brother had purchased the allegation in the article. I was implicated in the criminal case, which came to be quashed. Somewhere in 27 or
Quashed on what ground?
on merits as well as subjectivity. In that, the complainant had preferred a specially petition which was withdrawn. Subsequently, about a month ago, the state preferred a specially petition. But so far as suspension is concerned, it is multiple. Second matter, more than that, there is no order to continue under the police rule. There is no time limit specified as under CCL. Therefore, the judgment is against not counting. Another argument for merit is not any, but another argument is suspension is never a penalty unless it is specified as a penalty. Under the Police Act, suspension is a penalty. So therefore, placing in the suspension amounts to penalty. But in Karnataka, what happened? Before the Karnataka Police Act came before, Karnataka Police Act provided for penalty. After the Act came before, it was deleted from the Police Act, enacted under the Civil Service Act. Therefore, the penalty clause is deleted, but it is re-enacted under the Civil Service Act, but it's not available. I have a copy of the old act. There, suspension is specified as one of the penalties. Therefore, the extreme argument is that without holding an inquiry, they can't take it under suspension at all because specifically under the Police Act it's a penalty. Otherwise, suspension is never a penalty. The only exception is unless it is specified as a penalty. How is it specified as a penalty under the Police Act? Placing under suspension without suspension allowance here, it virtually amounts to my dismissal. Though there is no cessation of service, it's a part to take up at work. I have no salary, I have no work here also. 13 minutes they can dismiss me from service, but remove me from constitution. Is not practical. Therefore, here is the case where I'm here without
Notes the short submission, not on merits. Notes the tribunal's operative portion said that the application is hereby dismissed. Insofar as the continuation of the suspension order, it is for the respondent number one government to take a decision whether to continue the suspension order or to revoke it by conducting review of the suspension order. And it says the review of the suspension shall be conducted once in every 3 months also. Thereafter, my lords, after the dismissal of the petition, the suspension was the review of the suspension, my lords, was considered, and it was decided, my lords, to continue the suspension. Now, my lords, with regard to at the time of when the matter had come up, my lords, for before admission. In fact, my lords, what application is dismissed. So suspension, but when they sought for interim prayer at the time, the interim order that was granted for stay of the dismissal order. So which does not have anything. So unfortunately for him, my lords, it continued. They could have sought for stay of the suspension order at that point in time itself. I mean, so far as thereafter, my lords, as on the date when the matter had come up for admission, they had relied upon, my lords, the quashing of the criminal proceedings. And we had, the state had specifically made a submission that we are taking steps, my lords, to approach the Supreme Court. Now that in the additional statement, we had stated that it is a fit case and we are going. And in the meantime, my lords, SLP has been filed and notice has been issued. With regard to subsistence allowance, my lords, that is something I'll take instructions and ensure, my lords. But if I would request, my lords, because even in the operative portion, it says that suspension review has to be conducted every 3 months till conclusion of the inquiry proceedings or revocation of the suspension order. Now, inquiry proceedings, my lords, there is an interim order of stay. So both the petitions could be connected, one order could be passed. In fact, in the statement of option, we have brought out, my lords, the various offences, my lords, in which he is involved in. My lords, slightly sensitive matter for the state. So therefore, my lords, subsistence allowance, I'll take instructions.
From the date of suspension has to be given.
Please, my lords,
Date of
from the
suspension.
date of subsistence allowance, my lords, is
It is
something.
not given.
I will
It is
ensure, my
not
lords, I will ensure, my lords, that by the next date of hearing, I'll make submission on that. And my lords, that is something, my lords, you cannot keep him under suspension and not pay because it's a right that he is entitled to, my lords. That I will ensure that we do something about it, my lords. If I would only request, my lords, that other petition also, because if it is on a technicality, if it has to go, let it go instead of the matter being stayed. If suspension has to go, at least we'll expedite the disciplinary proceedings, and if it's issued by the inquiry officer, let the disciplinary authority consider it, so that both the matters could be taken up, maybe on Thursday, my lords. Because now the other case is connected, I will have.
Please give the numbers. Yes.
And subsistence allowance, my lords, I will ensure, my lords, that now I have appeared, I will ensure something happens.
Additional Advocate General submits that positive instructions with regard to the payment of substance allowance to the petitioner will be made available at the next date of posting. List along with the connected case on Thursday.
Please, grateful. No, lords, we will justify that.
We'll consider it, we'll hear him.
He says it's only on in charge.
Yes.
Please, grateful.
Mood matters come.
Mood matter. Vijay Kumar.
My lord, we have not been served a copy yet. So, I mean,
That may be so, but unless the government gets a copy, the government advocate gets a copy, how can he defend? Yes. Hmm. 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 Just a moment. All said and done. The examination is on 27.
Yes.
There appears to be an order appears to have been granted there, thereafter vacated, whatever, without any right being accrued. Can he be permitted to write the examination so that everything else we'll consider?
Shall I make one submission, madam?
Hmm.
If this is permitted now,
Hmm.
so many people will come like this, number one,
Hmm.
not for this examination, in
Hmm.
the future also.
Correct.
My lord, in the notification
Hmm.
itself, we have made clear, not only by online.
What was the date of the notification was
My-
26.
my lord, no, notification is in the month of February.
I see.
But I became
Prob-
eligible only on 6/6/24 because
One-
of one-time measure that
one-
was
one-
granted in
one-
this.
one submission, my lord.
Hmm.
The petitioner,
Hmm.
he appeared in the year 2017, 2018 batch.
Hmm.
And as a one-time measure,
Hmm.
the government has accorded a permission
Hmm.
to appear in this examination, even though they are overaged.
Hmm.
But the petitioner herein is not an innocent.
Hmm.
No.
He is one nimsha, sir.
Moment.
Please,
Just a moment, let us.
please, sir, please, sir. I will
Just
come to
hear
the
the-
point.
yes.
Please.
Wait, the bench had put a question to him. Let us hear him. Yes. Yes, please.
1 minute, my lord, 1 second. The, because sometimes my friend, my lord, at page number 38,
Hmm.
four types of, or four modes
Yes.
of payment we have given. One is net banking, debit card, credit card, and UPI.
Hmm.
My lord, he is not an innocent. He is working as Assistant Commissioner of Commercial Tax.
Oh.
Number one. Number two, my lord, I request my lordships to come to page number 146. 146, my lord.
Hmm.
146, wherein
Hmm.
that is the from 6/7/2024
Hmm.
to 21/6/2021, 15 days time we have given. What was he doing all those days? And now he is before the court stating that I have tried, because of that reason, I could not able to. No, my lord.
On
This
that day,
type of,
on that day, on 27, others could make payments.
well, at 20th, yes, my lord. 92 candidates have made on 20th. I request my lordships to come to even page number 153, my lord, for a moment. See, the petitioner should be fair enough to my lordships. 153, my lord.
Hmm.
Transaction expired.
Hmm.
Repayment. He has not tried at all.
Hmm.
He has not tried at all.
Repeatedly, my lord, the same.
On 20th. No, on 20th.
Yes. This is on?
20th, my lord. This is on 20th.
Hmm.
21st is the last date.
Hmm.
20th is, he has not called. 20th, he has not made any,
He would have made the payments through those four modes. Will you please?
Yes, my lord.
What were the four modes?
Four modes, my lord, at page number 36, 38. Page number 38, my lord.
Right.
Net banking,
Yes.
credit card,
Hmm.
debit card,
Hmm.
UPI.
Hmm.
Four modes.
Hmm.
If one mode was not in operation or, went wrong,
Hmm.
remaining three modes, he has not tried at all.
Hmm.
Now he cannot make an allegation against the commission stating that due to some problem, I could not able to make. So many people, the Pandora box will open, my lord. and he is not entitled, he is not an innocent.
Yes.
And we are supposed to abide by the terms and conditions of the notification. That is Bedanga Talodkar case, as rightly held by and in the Supreme Court, my lord, and also in many cases by my lordships. You have to abide by the terms and conditions of the notification along with the C&R. We cannot permit him to and we can. It is not at all possible for us to accept DD check, whatever it may be now. And entire thing is an online process.
I have applied, so and so his complaint is annexure A5. 20th July 2024, payment was made on the same day, but it got failed.
Ticket raised in the.
Yes. The rate
Is
payment
any
of-
permission, my lord?
Raised all these things, he cannot say that I have not tried. He doesn't know how it has happened.
How can I know? I can know, my lord. Yes.
The payment repeatedly, I was getting a confirmation, await confirmation.
Well, at
await confirmation.
20th, 92 candidates have made the payment on 20th.
My computer network
And
was not forthcoming.
That's not my mistake. I can't do anything. So many people will come before my lordships. No, my lord.
Yes, what is the order passed by the tribunal?
Lord, your lordship, kindly come to page 18, my lord. Yes, interim order that was initially granted was, my lord. Mary,
Yes.
Lord, we heard the learned counsel for the applicant and learned the AGA for respondent number 1, learned standing counsel for respondent 2. Learned counsel for the respondent 2 has filed IA for vacating the order, interim order granted on 7/8/24. We have perused the interim order granted by this tribunal dated 7/8/24 and the same reads as follows. We have perused the records. Respondent 2 KPSC is directed to permit the applicant to participate in the preliminary examination for the post gestate professionals, which is scheduled to be held on 25/8/2024, is subject to result of this application. Now, my lord, on the basis of the IA for vacating, which was filed on 21/8/2024 was the IA for vacating. Yesterday is 22. And I repeatedly requested to file, permit me to file an affidavit. The only contention of the KPSC was that I have not used the helpline. But I have tried the helpline and I could not get any response because it being a Sunday.
Please read the order.
Please. The counsel for the respondent 2 submitted at para 7 of the reply statement. There are 92 candidates who have paid their fees on 27/2/2024 and have remitted the prescribed fee on the set date itself. This is on 27, the last date was 21/7.
The payment failed was 20th.
Yes.
21/7, kindly note.
Sir, please, sir.
Yes, whatever.
No other candidate has submitted grievance on the set date complaining about the non-acceptance of the fee. The ground of the applicant that there was a technical snag internet issue problem in remitting the prescribed fee, hence he could not pay the prescribed fee, holds no water. In the meantime, the counsel for the applicant submitted on 21/7/24, the applicant has made grievances to the respondent through email, Gmail as per the annexure A5. But second respondent has not responded to the said mail. As such, last counsel for the respondent to submitted as per the notification period 26/2/2024 at annexure A1. There was a clear instruction to take help of the helpline number mentioned in the internal page number 3 of the notification. But the applicant has not taken help of the helpline number regarding online fee payment. As such, he has referred the decision of the Honorable High Court in the case of KPSC Bangalore versus LT Madhusudan and reported in so and so, which reads as follows. Now, this is with regard to category, choosing the category in the application, my lord, that is not applicable to my case. Now, my lord, however, the applicant being an assistant commissioner could not have taken assistance, could have taken assistance of the helpline provided under the recruitment notification. But without doing so, he simply sent the email to the respondent 2 on the next day and was last date of the payment of fees. Now he cannot be permitted to pay fees manually, which is not permissible as per the submission standing counsel of the KPSC respondent number 2. When the applicant has not followed the instruction given under the notification for his fault, he cannot blame the respondent. Under such circumstances, it is just as necessary to vacate the interim order. Now on 21/7/2024 is the last date and it being a Sunday, my lord.
Now where have you, where do you state that you had used the helpline and what is there to show?
But I have stated in my main application itself, my lord, that I tried to contact the applicant, sir.
Where do you say?
That is at page. At page 25, my lord.
Yes.
That para E. The applicant repeatedly tried making payment on the whole day of 21/7/2024. However, he could not get navigation through the payment gateway.
Further, the last day prescribed being a Sunday, he could not contact any officials in the office of the respondent. Applicant sent an email to KPSC requesting to assist him in making payment. Further, he also raised ticket in the KPSC portal on 21/7/2024. Copies of the email ticket raised in KPSC portal are collectively produced as annexure EFI.
Where is the contention that you use the helpline?
I tried to contact is the specific statement I have made. But I have tried to contact, even I have contacted the mobile office, they are unable to furnish me a copy, because there was no response from the helpline. They would not give me any document to show that I have contacted. But I have submitted application, I'll file an affidavit if necessary. Since the last date being 27, I'm only making an effort. And there was an interim order. They could have granted me 1 day, to secure information from the concerned mobile office, to secure the date on that particular date.
You had the time, you still have not produced anything.
I did not have any document to show that I tried to contact, tried
Not
the
stated
helpline.
so, Council.
Please, madam.
You have not stated so.
This is the first time they raised in the IFR vacating, First time they have raised this issue in the IFR vacating, and that was filed on 21/8/2024. Therefore, I practically tried the mobile office, to secure the information regarding the call records, They would definitely furnish me the call records, kindly. For a day, I sought accommodation from the KAT. They refused to grant me any time, to file objections to the IFR vacating.
Yes.
That para D, my lord. Para D, for a moment, page number 25. Shall I read?
Please.
The applicant submitted online application on 27/2024. Copy of which is produced as annexure 3. However, he could not make the payment of the prescribed fee through online due to some technical error. So and so, website KPSC as it was taking the payment and the applicant was getting await for confirmation. And 20th itself he has tried. What prevented him to contact the KPSC or come to the KPSC or call the KPSC? Now they are making an allegation against 21 is Sunday.
But I'm told,
Yes.
the mobile office will not give me the information regarding the unsuccessful calls, but anyway, I have filed an affidavit,
Yes, 20th, when was the application uploaded? You had-
20th, my lord. Page number 25.
No. You had produced something to show that he had tried only once.
Page 153, my lord. Transaction expired, repayment.
Stated in the affidavit.
Page 153 at the
Just a
bottom, my lord.
Yes.
Transaction expired, third column from the right side, my lord. Transaction expired, repayment.
But this is one such call and I have produced it. Repeated calls, I have not produced it. It is only to show that I have made efforts. He cannot say that I have tried only once. When you see the date, my lord, at 10:43 AM, my lord, I have tried. At the top of the page.
10:43 on 20th.
On 21, my lord. On 21.
He being an assistant commissioner of commercial tax,
Lord, on-
Difficult.
Lord, you'll ask me kindly, see, my lord, it's only I'm seeking an effort, my lord. to
Exactly,
Write the
exactly.
exam once again, my lord.
Exactly. If you were,
I have tried all my efforts, my lord, it was a Sunday, my lord.
if you were a fresh applicant and you could, and you did not have the other options and all that, that is,
Sunday, my lord.
there are 4 options available, Council.
Lord,
4 options to make the payment, including UPI.
15 days time.
ask me kindly, see, my lord, I was also working, my lord, I could not go through this formalities of the application in time, my lord. But as on the day when I tried, my lord, it was the last day and it was within the time, my lord. Lord, 27th is the exam, Lord. I have only one last chance, Lord. Let them permit me to participate in the examination. I had the benefit of interim order, my lord. Without giving proper opportunity, my lord, they have vacated the.
No, you have the opportunity, Council. Even now, nothing is forthcoming.
Right, mobile office, my lord. I will be getting that information, my lord. By Monday, I will be getting the information, my lord. Kindly permit me to participate in the proceedings. My lord, I will file an affidavit with regard to the making efforts to, my lord, get the contact with helpline. Please, my lord, this is the last chance I'm getting.
Totally, we did not accept that. Special case is, as rightly pointed out by Lordship, is a pressure. You can have a special case. 2 weeks time, he's the Assistant Commissioner of Commercial Tax, he was busy in his work. He's so negligent towards this. He's not interested, that itself shows. Hence I request my Lordship to reject the. And there is no provision for the KPSC now to accept the fees and to issue the certificate my lord manually. Yes, my lord. Yes, my lord. No, it's 100%. My friend is wrong. My friend is wrong. I am right. They are making,
That again is an issue, a special case in respect of a person who has all the mechanism to make the application within time. We don't. Yes. Yes. No, if there is no question of granting permission, if there is an interim order, they have to, but that is not the question. Whether you had the opportunity to make that application and the payment in time, and it was only because of, yes. There were 4 methods of payment. Everything failed. Yes, what do you say?
But several opportunities have been given. There were options, several options, and as well as the time has been extended. I noticed that in page 146, time has been extended by.
Yes, it was
15
only
days.
the extended time that was to expire on 21.
So all opportunities have been given. So
What was the?
if further
earlier
opportunities
time?
are given,
What was the earlier time granted, the last date? Hmm. Hmm.
They gave only time for almost 14 days.
how many submitted?
It was given.
92
It was, as a matter of fact, given.
submitted.
It was not something that you did not have, the application and the making of the payment.
92 have submitted on that day, and my lordships is well aware. Nowadays, in a fingertip, my lord, the payment will.
The difficulty was I was working, my lord, I was in the commercial tax department, my lord. My lord, only on the weekends, my lord, I will be able to go through all these things, my lord.
We are giving time till today. There are several others who could have applied. If we are giving you time till today, there are several others who could have applied.
Today is the last day. Today is the last day, my lord.
Today is the last date for what?
Board working is today is the last day, my lord.
Exactly.
They are trying to.
Exactly, from 21st to 21/7 to today.
Yes.
There are several others who could have applied,
No, my lord.
who have been denied of the opportunity.
My only
Yes.
suggestion, my lord, I had the benefit of interim order on 7/8, my lord.
Yes.
Last time I told you, my lord, that benefit which was extended to me, my lord, on 21/8,
Yes,
my lord, I
please.
filed an application.
Madam.
Heard both sides. In the facts and circumstances of the instant case, as is brought out from the materials placed on record, and in view of the fact that the last date for submission of the application had been extended, and further in view of the fact that the petitioner was not a fresh entrant into service and is presently working as an Assistant Commissioner of Commercial Taxes. We are of the opinion that the interim order as sought for in this writ petition cannot be granted. We find that we find from the submissions made by the Learned Counsel for the respondent, that 92 persons had made applications and payments on 27/2021. Therefore, the contention made by the petitioner, further 4 modes of payment had also been specifically provided in the application, including
Net banking,
pay-
debit
net
card, credit
banking,
card, credit card, debit card, UPI.
as well
my
as
lord.
UPI. In the above circumstances, we are of the opinion that the vacation of the interim order by the tribunal does not call for any interference. The writ petition fails, same is accordingly dismissed.
Gratefully published.
Give dates.
Sir, sitting
Really, there is a division bench matter. After that, I've suggested few things to him. I don't know whether he has communicated to you. I've suggested sort of settlement. So at the end of the day, it is a speculation for the judge whether he died before 1956 or after 1956. Wednesday? This is meet on Wednesday.
ನಮಸ್ತೆ ಸರ್.
ನಮಸ್ತೆ ಮೇಡಮ್.
ಚೆನ್ನಾಗಿದ್ದೀರಾ ಸರ್?
ಚೆನ್ನಾಗಿದ್ದೀನಿ, ತಾವಾಗಿದ್ದೀರಾ?
ಚೆನ್ನಾಗಿ. ಇನ್ನೂ ಹೊರಟಿಲ್ಲ ಸರ್, ಮೇಡಮ್ ಬರ್ತಾ ಇದ್ದಾರೆ.
ಆಲ್ ರೈಟ್, ಆಲ್ ರೈಟ್.
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೇನು ಒಂದು ಡೇಟ್ ಇದೆ ಸರ್, 30th.
ವಿಚ್ ಮ್ಯಾಟರ್?
ಅದು ಮಾಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಒಂದು ಇತ್ತಲ್ಲ ಸರ್.
ರಿಟ್ ಪಿಟಿಷನ್?
ಕೌನ್ಸಿಲ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅರವಿಂದ್ ಕಾಮತ್ ಅವರು ಮತ್ತೆ
ಕರೆಕ್ಟ್ ಕರೆಕ್ಟ್. ವಿ ಕಾಲ್ಡ್ ಫಾರ್ ರಿಪೋರ್ಟ್ ಫ್ರಮ್ CBI.
ಹೌದೌದು, ಅದೊಂದು.
Afternoon. I'm sorry for the
Namaste.
delay.
Namaste, madam. Namaste. Not at all.
I have a review, which is a constituted bench. It's to come before your lordship. I have requested for Tuesday or Wednesday, suiting your convenience. But the board branch says it will come only on Friday. I said, no, I make a personal request. I can give the details.
Is it a review before this bench?
Yes, yes. So I'll be grateful if you say yes. Lordship says yes, I will give the copy. I came rushing up.
Yes.
Tuesday.
Please inform the.
Yes.
It cannot be listed on Tuesday. Please inform the court officer because this will have to be, bench will have to be specially
already-
constituted. Please inform the court officer. We'll see how it can be done.
Bench is already constituted. Justice Yeru along with that. So I requested for Tuesday.
Okay.
Thank you.
Matters pertaining to People Bench, Bangalore, hearing on IA, seal number 1, K. Narayan.
Appear for the respondent in this matter, my lord.
My lord, I am for proxy counsel for appellant. The appellant has requested me to apprise this court that his sudden demise of his relative has left to Chennai today. Next date, please.
If I may please request the delay to be condoned and the IA to be allowed, my lord. Since there's an IA filed seeking recall, there's no representation because the advocate who was appearing for the respondent previously remained absent because of a spinal cord injury, and then she could not.
There's an objection as well filed by. the
Objection is
applicant.
already filed by them. And they're only saying
What are
that,
the facts of this matter? Is they have been living separately?
please, my lord, the
Since when?
divorce was not granted before the trial court. Subsequently, in appeal, divorce is granted now.
Never. Since when have they been living separate?
My lord, it's not so simple only for the reason that I am given to understand that the appellant was living with also another woman and also with the respondent. And then during such time, we have even produced documents to show that the entire endeavor to do this is to leave me and start a new life with another person, which he had done even prior to the divorce. That is the reason why. And one other thing is, my lord, there is alimony part also that is left open. And even otherwise, the fact that he was so essentially the divorce regularizes an adulterous relationship.
As
That
a
is,
matter of fact, it is something with to do to the alimony aspect is also involved here.
that is only if this court is not going to consider the aspect of divorce at all, my lord. On merits also, we want to address on the ground that this relationship that he is trying to regularize, or that he may claim now, saying that since the appeal has been allowed,
How can that be?
that is not at all the case. So even,
Even if that is so, it is during the substance of the marriage.
yes,
It's
so which is
completely a different matter, and it is
on merits, we would
ultimately issue of
on merits, we would want to contest, saying that there is no grounds for divorce, my lord. That is the.
is it
So
not
for the last
something-
12 years,
Yes.
for the last 12 years, you have been living separately.
Please.
The question relating to alimony is not foreclosed. That is still open to you to
Please.
make a claim. Why don't you explore the possibility of settlement?
Please, my lord, if
Basically, that is
it is actually not that, though I know that generally it is that now that anyway the divorce is granted, at least she can be given some maintenance would be the view. But my instructions are that we want to contest on the merits, saying that the divorce could not have been granted because the grounds are not made out, because the facts are different, my lord. That is the instructions that I have.
Can you not make an attempt to
I
settle the matter?
will see if I can prevail over my client and inform her if we can think of some sort of a settlement. And if that is possible, then we will at least explore that, my lord.
Ultimately, even if we
Yes.
don't grant the divorce,
Please.
what happens? The marriage is not going to be put back together, specifically in view of what you have stated.
Please.
If there was an adulterous relationship, there is another person involved.
Yeah, there is a child out of another relationship. We have produced all
It's
of
not-
them.
Obviously, it's not going to help you to put back your marriage together.
That is true, my lord. We have tried saying that for whether divorce is granted on a right ground or not, to revive the relationship is quite difficult.
If as a matter of fact,
Please,
a
my lord.
settlement is arrived at, all these findings with regard to the cruelty, everything goes.
Please. In all likelihood, the other hope of trying to revive the relationship is that she'll be maintained by him. If that maintenance is going to be granted, despite the fact that divorce is there, I'll prevail on my client and see if we can advise her to explore the possibility of settlement. I'm told that the bench may be there on the next Friday also, my lord, if it may be taken up next Friday, my lord. Yes,
We can
Yes,
make an
madam.
attempt on next Friday.
please.
that-
By which time
Now
I'll,
that
Yes,
we
madam.
are informed that we have to sit on next Friday as well. Yes. Yes,
next Friday, my lord. Grateful.
Thank you. Bye.
please explore this possibility in all seriousness.
Please, please.
Yes.
Still number 2. Government.
This is a
Yes. What
this
is
is a
the
review
purpose?
petition.
Review?
Regarding commuted value of pension.
Hmm.
Lords, interest was granted
Hmm.
by the tribunal, my lords, on the delayed payment of the terminal benefits
Hmm.
of DCRG, my lords, and commuted value of pension.
Hmm.
And we had challenged by filing a writ petition,
Hmm.
only that portion of the order
Hmm.
whereby, my lords, commuted value of pension, my lords, interest was granted, not on the DCRG.
Hmm.
Now the entire on the DCRG amount has been paid,
Hmm.
the commuted the interest amount. It
Hmm.
was only, my lords, on commuted value of pension, my lords, that interest portion has been challenged.
Hmm.
Now, my lords, his date of retirement was on 31/10/2011.
Hmm.
on June, in June 2012,
Mm.
we have settled his provisional pension
Mm.
with effect from 1/1/2011, the next day of his retirement.
Mm.
And that amount, my lords, was 39,175.
Mm.
Now, my lords, from that day, 39,175 has been paid.
Mm.
Finally, my lords, after the DE got closed in terms of the quashing orders, my lords, in 2018, his pension was settled and it remained the same amount, 39,175. Then, my lords, at that point in time, we have given him commuted value of pension. Now, my lords, out of 39,175, he has for maximum is 40% for which he could opt for. And 15,670 my lords was deducted. And thereafter, the entire lump sum of 15,40,800 has been paid to him. Now, he is claiming for interest portion on 15,40,800 rupees from the date of retirement to the date of payment. Now that, my lords, tribunal had granted. We had only challenged that portion of the order. My lords have dismissed it, my lords. But insofar as commuted value of pension is concerned, my lords, he is out of the total, if 100 rupees is the pension, maximum 40%, my lords, he can seek for commutation. So therefore, he gives up 40 rupees and a lump sum is fixed and he gets the entire lump sum. But from 2011 to 2015, the entire amount was paid, including that 15,000, including that 40% which has to be deducted. He had the benefit, my lords, of the entire commuted value from 2011 from the date. Then, my lords, when 2018, we permitted the commutation, 40% is deducted and he's being paid the remaining amount and the deduction continues and he gets the entire amount of 15 lakhs.
Only on the remaining amount is the interest ordered.
No, my lords, interest order is not on the remaining amount. Interest order is on the 15,40,800.
Whatever was not paid to him in time
Please, my lords.
he had sought for commutation earlier itself, as on the date of his
No, my lords, as
retirement,
on
he
the day, he could not do it because of pendency of DE.
whatever he sought commutation.
Please, my lords.
The DE ended without any fault being fixed.
It was quashed, my lords.
It was quashed.
Please.
Therefore,
No fault
he
of
could
his.
he would be entitled to commutation
Please,
with effect from the date of his entitlement.
from the date of his entitlement, but my lords, 15,440, kindly note this figure, my lords, 15,40,800 is the commuted value.
Understand?
We have paid him.
We understand that.
Please, my lords.
Ultimately,
Huh.
what is the interest on?
15,40,800.
The delayed payment.
Please, my lords.
Therefore, whatever has been after the delay,
Please, my lords.
whatever has been paid carries interest. That is all. We are.
No, my lords, but kindly note one fact. On the delayed payment, if I give him 15,400, then I have to deduct 15,670 from that day. See, his entitlement to 15 lakhs is only on deduction. Out of his 100 rupees, I'm deducting 40 rupees and paying him. In fact, my lords, the interest amount will come to 8,63,000. But
Advocate General getting 35 lakhs in lump sum.
Please, my
and
lords.
getting 15,000 excess in a month
Please, my lords.
are two different
No, my
things.
lords, the interest amount is what has been calculated will come to 8,63,618. But for having taken 15,000 rupees excess every month.
Now, all we have said is.
Please, my lords.
that petition is dismissed.
Please, my lords.
Petitioner shall pay the interest on the delayed payment of commuted value of pension
Please.
to the respondent as directed by the tribunal.
Please, my lords. The
That
tribunal.
is
my
all
lords-
we have said.
Please, my lords.
Therefore, whatever it is that the tribunal has said, you can.
No, my lords, but on commuted value of pension, as a matter of policy, even as a matter of rule, that rule, my lords, was not, there is a rule. IAS officers kindly see, my lords, one rule, which is at
No.
page number 22.
No, what is the review in respect of? We have
My
not
lords,
said
review,
anything.
what we are seeking for is, my lords, kindly note one fact. If I pay him interest, my lords, delayed payment is on 15 lakhs.
Two things.
Please, my lords.
You were in appeal before us with regard to payment of interest.
Please, my lords.
Nothing else.
Only on interest, my lords.
Interest on commuted value of pension, nothing else.
Please, my lords.
Therefore, we considered your contentions
Please, my lords.
and rejected them. So whatever it is that is payable as per the directions of the tribunal, you have to pay. If you have any contention that there is any error in the direction of the tribunal, the review has to be attempted there,
No, my lords.
not
the-
here.
My lords, now that the order of the tribunal has merged with my lord's order, we have relied, my lords, on a circular at that point in time. my lords, our petition has been dismissed on the ground, my lords, that the petition was filed two years, my lords, after the order was passed. But on principle, there is no, he has not been deprived of any amount. Let's kindly note one fact. If in terms of the order of the tribunal, if I am liable to pay 15 lakhs interest on 15 lakhs 40,000 lump sum from 2011 to 2018 at 7.1%, my lords, the amount is 8 lakhs 63,000. But his entitlement to 15 lakhs was subject to commutation of 40%. So for the entire 6 years, I have paid him the entire 100 rupees. If I deduct that 40 rupees, now I have paid him 14 lakhs excess. He has been paid 14 lakhs 88,000 for the entire period of 15,000.
Why did you? For the period when he was paid the full pension, he
There-
did not have been
No,
granted.
therefore, my lords, on
This is your mistake.
no, my lords, on commutation, my lords, when provisional pension is settled, there is no provision for commutation. The entire amount is paid to the servant. The commutation is an option that he takes. The moment when his final pension is settled, from that day, my lords, he gets a deduction. Instead of that deduction, he's entitled to get. Conceptually, my lords, interest will not come at all because interest is,
That
if I've
is, if as a matter of fact,
please, my lords.
you have paid both the commuted value, reckoning the entire period,
Please, my lords.
as also the pension for part of that period. That is a calculation that you can make.
No, my lords, but that observation is not, my lords, now, my lords, it will be a double benefit, my lords. Literally, it will be an
Exactly.
unjust enrichment because he has had the benefit of that 15,000 per month.
All this is subject to
Please, my lords.
the fact that these two payments have been made by you.
Lords, as when I settle a provision pension and it is an admitted fact that he has received that amount. It conceptually, my lords, there is a error in the order is what we are saying, because in terms,
In the order, in your calculation. If as a matter of fact, you commute the pension only in 2018,
please, my lords,
that is your contention.
please, my
You're
lords.
commuting the pension only in 2018
2018,
because of various
various
factors.
reasons, my lords.
When you're commuting in 2018,
Please,
you cannot, if you're commuting with effect from the earlier date,
please, my
then
lords.
there must be a deduction made for the full pension that you have paid till 2018. Why didn't you do it?
Because more will be deducted from him to ensure that it inures to their benefit. We don't deduct that it is from that date. Otherwise, my lords, I will to pay him 8 lakhs. Technically, my lords, I must quote.
Sir,
because
ಮತ್ತೆ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಕಾಪಿ
he's
ಕೊಡ್ತಿದ್ವಲ್ಲ ಸರ್ ಅದು ಶಂಕರ್ದು ಅಲ್ಲ ಅದೇ ತರ
lords, his deprivement.
Yes.
Let's make by his deprivement, my lords. For example, if I had paid him, my lords, from that date, now his entitlement to interest is as if he's entitled to from the date of the retirement. Now, if from the date of the retirement is entitled to whatever deductions have to happen from that date should happen. But if that deduction happens, it'll inure to his detriment because that deduction will be 15 lakhs. The interest I'm going to pay is 6.5 lakhs. That is how
That's the.
kindly see the calculation I've given, my lords. In kindly see paragraph number. Lords, 4 of my petition, review petition. Petitioner submitted that the above observations made by this honorable court is erroneous in face of the record because
Two things you must first
Please,
tell us.
please.
If this is, how can the provisional pension and the final pension be the same? It can.
My lords, in case it was less, I understand, my lords, that on that, and for example, usually sometimes provisional pension will be 90%. Here, my lords,
70%, even
it
certain
could be, my
cases.
lords, but in this case, my lords, the provisional pension
was given as
pension
as provisional pension.
and final pension is also the same amount.
Okay.
So if there was 10% which was not to be paid, I understand, my lords. Kindly see, my lords, the respondent has received 100% of the provisional pension. That is sum of rupees 39,175 from 1/11/2011 to 30/11/2018 as the respondent retired from service on superannuation from 31/10/2011. A copy of the said so and so we have produced. The petitioner submitted that an amount of rupees 15 lakhs 80,000 or 15 lakhs 40,800 as commutation value of pension was released to the respondent on 13/12/2018, and thereafter an amount of rupees 15,670 per month was deducted as less commutation value of pension. Since an amount of rupees 15,670 per month, that is 15,670 into 85 months in total, 13 lakhs 31,950 from 1/11/2011 to 30/11/2008 is already paid to the respondent.
Hmm.
The petitioner submitted that respondent number so and so has received provisional pension of a sum of rupees 39,175 from 1/11/2011 to
We
30.
understand the contention. This
Please.
was not your argument before us in the writ petition. This was never argued before us.
Lords,
This is
that-
the first time this is being argued.
Lords, I'll,
It's not the argument.
please, Lords, I,
Do you agree, brother?
Yes, where is this ground, Mr. Jacob? The ground which you have now raised in the writ petition,
It's not
where
the
it is
ground.
found in the
Definitely not the
writ
ground.
petition?
Because
Lords,
it
we
was
had-
not argued before us.
no, my lords, I will say, we had relied upon, my lords, a circular
Yes.
that was there, and that circular, my lords, had held it that it does not apply. But in fact,
Your contention was this.
please, my lords,
Because commuted value of pension has to be paid only once the commutation is accepted.
please, my lords,
He would be entitled to full pension
please, my lords.
and therefore no interest is payable on the commuted value of pension. This was the specific argument.
Lords, and there is one more thing, my lords, I get it, my lords. Kindly see annexure.
Here the responded on this, but this was not the ground on which
Lords,
it was
I get it,
argued.
my lords, but this is, my lords, on commuted value of pension, my lords, if interest has not been paid, annexure C also may kindly be seen for a moment.
Yes, your contention was that interest is not payable because
Because of some
Com-
circular was,
it was the circular.
but,
What we had considered was
please, my lords,
commutation is a benefit which is given as a lump sum, you get the amount.
please, my lords.
That, as a matter of fact, is the biggest aspect of the
Commutation,
pensionary benefits.
pensionary benefits.
Biggest,
Please.
the most considerate aspect of pensionary benefits. So getting it as a whole
Please,
is, if all other, it is not a complete right or whatever, but everything else being met,
please,
he has a right to commute to his pension.
please, my lords,
To get it as a lump sum
please,
would be, and if it is not granted as a lump sum for no reason at all,
please, my lords.
then it would be, interest would run on it was what we found. We
But if-
said a circular which says
Please.
that commutation being, because you are drawing the earlier amount, you're not entitled to interest on commutation,
Please.
is not a proper, that was the only thing that was argued. The fact that there's an error in the calculations made by you was never argued before us.
Lords, we had relied on the circular,
Mm.
but they had stated, my lords, that that circular will not apply. The other said, the party
Exactly,
in
the
person.
circular you had
Not-
relied on.
No,
but
not
you
only
had
that,
not
Lords.
contested that there's an error in the
There-
calculation.
Lords, there was also one other thing, the All India services,
Hmm.
there is a separate rules also, my lords, which specifically provides, my lords, that only for DCRG it is payable.
Hmm.
For computational, whatever conceptually I argued, that is
Hmm.
also provided for in a separate rules.
Hmm.
Unfortunately, that was also not brought to the notice of the court. My lords, it will have some ramifications, so therefore, at least notice may be issued.
Yes, what about the delay? There's only,
19 days.
19 days.
that can be condoned.
No, my lords, the other side is of the
Yes.
party in person, notice has to be issued.
They're not here.
They're not here, my lords.
You've
Yes,
not,
Rajkumar is a government.
You've not served,
We had served a copy and informed him, but since he's a party in person,
Sent by
yes,
mail.
issue notice.
grateful.
Can we issue notice in the delay petition as well as on the review
As well as,
petition?
please.
Yes. Let notice go so that they can. Yes, this was not,
Lords, I get it.
any error in the calculation was absolutely never argued. You'll agree with us. It was not argued.
Lords, we're grateful, Lords, for the
We are
notice.
in a
As
review.
At the time,
This
we
is
was
the
I get it,
legal-
I get. No,
only
Lords,
submitted clarification and that.
All
correctly
that
was
was
accepted.
argued was this, that because it is commutation
Now we
and
placed
because
original rule.
commutation takes effect only once it is allowed,
Yes.
once the application is allowed, no interest is payable. Fair enough, but the difficulty is you're getting an amount as a lump sum. And if it is ultimately found that you're entitled to that amount, why was it not given at the earlier point in time? If that not giving at the earlier point does not have a justifiable explanation, then he's entitled this aspect
But
is never argued.
if the lump sum is related to, my lords, a deduction, and the deduction was not made all along, and he had the benefit of that entire amount, so that is only.
If that is so, that should have been a
I
ground.
get it, my lords. We are grateful for the notice, my lords. Great.
Yes,
Further hearing, seal number 3. Vivek Kolla.
in the
last occasion.
Yes.
For making, my lord, we have already sent the list of enactments and the government orders to the Kalaburgi bench.
Yes, yes.
And also list of citation. ಏನೋ ಒಂದು government
Is it available there, brother?
Yes, it's available, madam.
Wait. Circulars ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ಕೊಡಿ. ಇಲ್ಲ 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 ನನ್ನ ಹತ್ರ ಕೊಟ್ಟಿಲ್ಲ. I have also received one. In fact, Lords, the substantive, or I should not say substantive in substance, but a lot of time was taken by the respondents on reading, rereading R.K. Sabharwal. No matter, the question is this, whether R.K. Sabharwal is applicable at all in matters where issue is about seniority and recruitment. In Dr. Arun Agarwal's case, Arun Bhatnagar's case, Supreme Court, after elaborately considering R.K. Sabharwal, has held that in matters of those aspects of service jurisprudence which are governed by Article 16(1), R.K. Sabharwal is not applicable. And it has also held in a recruitment rule, whatever be the word used, whether it is post or whether it is vacancy, it has to be read as vacancy soon. I have placed that judgment in my, I'll just take my lords to the. Subsequently, a 3-judge bench, because Dr. Arun Bhatnagar was rendered by 2 judges. Subsequently, in 3-judge bench in All India Central Excise Federation, Arun Agarwal was approved. Arun Bhatnagar was approved. And in the last but one paragraph, V.B. Badami was reiterated. V.B. Badami, I have taken my lords elaborately. I don't want to say anything. If my lords would kindly take the compilation of judgments that I have filed in the writ petition. That is, my lords, on 19th April 2022, I have filed. Is V.B. Badami, that is different. It's the last handover ಮಾಡಿದ್ರು ಸರ್.
Yes.
Arun Bhatnagar is judgment number 3 there. At page 17 of the compilation. Madam, ಈ ತರ ಇದೆ compel ಇದೆ ಸರ್.
Not this. 15,422. This is 10.
ಯಾವ್ದು BP ಬಾದಾಮಿ ಅದ್ರಲ್ಲಿ ಬೇರೆನೆ ಕೊಟ್ಟಿದ್ದೀರಾ ಅದರಲ್ಲಿ ಆರ್ ಎನ್ ಸಬ್ರವಾಲ್ ಆರ್ ಎನ್ ಅಗರ್ವಾಲ್ ಸಾರಿ ಮಲಾಟ್ serial number differs.
Serial number.
Arun
In this.
Arun Bhatnagar release. Arun Bhatnagar extra copies ಇದೆಯಾ? Arun Bhatnagar is 1999 volume 2 SCC, page 330.
1999, volume 2 SCC.
Yes. It's volume 2 or volume 3?
It is volume 2, my lords. 1999,
Volume
2 SCC 330,
330.
330. May I, my lords,
Just, is there?
Huh? My lords,
SCC 330 is not cited.
my lords, I have an extra copy
Yes.
here, but only thing is I have, I don't know whether Lordship Justice Hegde is getting there in court hall itself, the SCCs are available in
Is it
Gulbarga
there,
site.
brother? 1999,
Yes,
2
Kalburgi is
SCC.
quite fast, madam.
Kalburgi is
Yes,
quite
Kalburgi is
fast.
quite fast.
Faster than Bangalore. Very good. Yes.
Because when Kalburgi started, SSC had already commenced long years ago. And when the principal bench was established way back, at that time, our SCC was unknown. Therefore, they being present day
Yes.
establishment,
The present generation.
present generation, we
faster.
are the old generation.
Correct. Correct. 99, 2 SCC 330.
330. In the compilation that I have given to my lords,
Hmm.
that is at, I think, same. My lords may see in the index what is the
Yes, yes.
judgment number.
Hmm.
If my lords would kindly take the paragraph 3 of that judgment, which is at page 336.
Yes.
There, recruitment rule that came up for consideration is extracted. The respondent at the relevant point of time when this controversy arose was working as assistant professor in the Department of Ophthalmology in Government Medical College, Patiala. He was a promotee with effect from 20th June 1984. Earlier, he was working as senior lecturer from 6881. The question arose as to how the vacancy in the post of professor of ophthalmology was to be filled on the retirement of one Dr. Shiv Inder Singh Rudra, professor of ophthalmology, with effect from 31/10/1996. The relevant rule governing such posts is Rule 9(1)D of Punjab Medical College Education Service Class 1 Rules 1978. Hereinafter referred to as this. The said rule reads as under method of appointment. In the case of professors, 75% posts by promotion. Kindly mark that word promotion. Then next, 25% posts by direct recruitment. The entire controversy arose because of the words used posts. R.K. Sabral law would apply. That was the controversy. Kindly turn to para 7, where argument relying on R.K. Sabharwal is noticed. This is found Learner Council for this.
Paragraph 4 says there is a rota also provided.
There is a rota also that I will explain because there is
Promote
here
second
there is
details.
ultimately the question is here there is no rota. Therefore, the only question would be how that word post will have to be understood. Para 7.
Yes.
The so-and-so Learner Council, on the other hand, submitted the ratio of the decision R.K. Sabharwal was rightly applied by the High Court. There we stop, go to para 8, minutes. In the light of the aforesaid rival contention, the following points arise for our determination. Whether the interpretation of Rule 9(1)D, which appealed to the High Court, is a correct one. That is interpretation in the light of, on the anvil of R.K. Sabharwal. Consideration commences at para 9, page 339. This is little longish paragraph, my lords. So far as the first point is concerned, High Court in the impugned judgment has heavily relied upon the Constitution Bench decision of this court in the case of R.K. Sabharwal. Now it has to be kept in view that the Constitution Bench of this court in the aforesaid decision was concerned with entirely a different question, namely as to how the roster indicating reserved points in connection with reservation of posts in a cadre to be filled in by scheduled castes or scheduled tribes and backward classes should be operated. Para 4 of the report lays down. When a percentage of reservation is fixed in respect of a particular cadre and the roster indicates the reserve points, it has to be taken that the posts shown at the reserve points are to be filled from amongst the members of reserve categories, and the candidates belonging to the general category are not entitled to be considered for the post. In this connection, reliance was placed by the Constitution Bench on Article 16(4) of the Constitution of India, which permits the state government to make any provision for reservation of appointments or posts in favor of any backward class of citizens, which, in the opinion of the state, was not adequately represented in the services under the state. In the light of the aforesaid scheme of the Constitution, the bench had to consider whether reservation of posts for SC/ST, when sought to be secured by way of operation of the roster, would permit the operation of the roster qua the post or vacancies in the cadre. It was noted in this connection that if the roster operated on vacancies, then it may happen that at a given point of time, the percentage of reservation of posts for SCs, STs, and OBCs may exceed the permissible percentage of reservation. In para 5 of the report, it was observed that reservation provided under the impugned government instructions permitted 16% of the posts to be reserved for SCs and BCs, and it could be achieved by the roster to be maintained in each department. The roster had to be implemented in the form of running account from year to year. In connection with 16% of quota to be reserved for members of SCs and BCs in promotional posts, it was held as under. When recruitment to a cadre starts, then 14 posts earmarked that my lords may skip. Then my lords may come to the line 3 at page 340. The efforts of the observations, which are heavily relied on by the High Court and are also relied upon by the respondents, writ petitioners counsel, cannot be of any assistance to the appellant state on the facts of the present case. The result is obvious. As per Article 16(4), which carves out a separate field for itself from the general sweep of Article 16(1), which guarantees equality of opportunity in matters of appointments in government services to all citizens of India, the reservation for these categories of posts have to be achieved by earmarking the requisite percentage of posts for the reserved category candidates and by pitchforking these posts on roster points on requisite points roster, and then such a roster takes a full cycle. Posts earmarked on reserved points will enable the requisite reserved category of candidates to fill these posts. After that is done, the roster will be treated to have achieved its purpose. Whenever a reserved candidate vacated a reserved post, the said post was liable to be filled only by a candidate belonging to the reserved category. If after the roster is first operated and thereafter it is again operated on future vacancies also, a situation may arise when the cadre may get reserved category exceeding the permitted quota of reservation. It is to avoid this contingency that the Constitution Bench laid down in the aforesaid decision as indicated therein. So far as Rule 9 of the rules in the present case is concerned, it has nothing to do with reservation of posts in the cadre of professors. It is not a rule of reservation envisaged for a category of persons as permitted by Article 16(4) of the Constitution. On the contrary, this is how it interprets, my lords. It is a rule of recruitment from two different sources, namely in case of professors cadre, 75% of the posts to be filled by promotion, while 25% by direct recruitment. These two sources of recruitment permit departmental promotion and direct recruitment from the open market to get absorbed into the cadre. They merely serve as two entry points for the cadre. Rule 9 deals with reservation of appointment to the posts of professor and does not deal with reservation of posts of professors for any class or category of candidates. It is well settled that once a recruitment is made from two sources, departmental promotees and direct recruits from the open market, and once the candidates concerned enter into any cadre through entry point reserved for them, they get fused and blended into one single cadre and their birthmarks get obliterated. In this connection, we may usefully refer to a Constitution Bench decision of this court in state of Jammu and Kashmir versus Trilokanath Kosa, speaking for the Constitution Bench while dealing with the recruitment to a cadre from two sources, namely direct recruits and promotees, in the light of an earlier judgment in Roshanlal Tandon, made the following pertinent observations. Then that para 44 is extracted. The last 5 lines of that paragraph. To put it differently, once the direct recruits and promotees are absorbed into one cadre, They form one class and they cannot be discriminated for the purpose of further promotion to the higher grade C. In terms, this was just a different way of putting what had preceded. Thus, all that Roshanlal case lays down is that direct recruits and promotees lose their birthmarks and fusion into a common stream of service, and they cannot thereafter be treated differently by reference to consideration that they were recruited from different sources. Their genetic blemishes disappear once they are integrated into a common class. Then after interpretation, it is laid down like this. It has therefore to be appreciated that when posts in a cadre are to be filled from two different sources, where the candidates come from source of departmental promotees or direct recruitments, once both of them enter a common cadre, their birthmarks disappear and they get completely integrated into the cadre. This would be in consonance with the thrust of Article 16(1) of the Constitution. No question of exception to the said general rule thrust on the constitutional provision would survive, as Article 16(4) would be out of the picture in such a case. Consequently, the decision rendered by the Constitution bench in R.K. Sabharwal case in connection with Article 16(4) and the operation of roster for achieving the reservation post for SCs, STs, and BCs as per the scheme of reservation cannot be pressed into service for the present scheme of Rule 9(1) is not as per Article 16, but is governed by the general sweep of Article 16(1). The attempt of the learned counsel for the respondent to treat the quota rule as a reservation rule would result in requiring the state authorities to continue the birthmarks of direct recruits and promotees even after they enter the common cadre, though through two separate entry points regulating their intention into the cadre. Therefore, the roster for 3 promotees and 1 direct recruit is to be continued every time a vacancy arises, and there is no question of filling up a vacancy arising out of a retirement of a direct recruitment by direct recruitment or on the retirement of a vacancy of a promotee by a promotee. Consequently, the question of rotating the vacancies as posts or for treating the posts mentioned in the rules are necessarily referable to total posts in the cadre at a given point of time in the light of R.K. Sabharwal cannot survive in the case of a quota rule between direct recruits and promotees. The same is to be judged on the touchstone of Article 16(1) and statutory rules governing recruitment to the posts of professors in the etc. on the basis of Article. Division bench in the impugned judgment with respect wrongly applied the ratio of R.K. Sabharwal governing 16(4) to the facts of the present case, which are governed by Article 16(1). There, my lords, in this paragraph, they say that every time a vacancy arises, the word used in the recruitment rule, I pointed out some para 3 is post. It said it has to be read as vacancies. Then, my lords, we may also mention that in brief written submissions filed on behalf of the respondent, an attempt is made to show the word reserve means to appropriate or set aside. The dictionary meaning found in the Law Lexicon 1997 edition Ramnath Iyer is pressed into service in this connection. It is stated therein that reserve would mean to set apart. But as we have already discussed, Rule 9 is concerned with reservation of appointments from 2 sources of recruitment. It does not envisage a scheme of reservation of posts. Consequently, as aforesaid, the dictionary meaning of the term reserve cannot advance in the case of respondent. Then it proceeds to say, what should be the law to be applied? On the other hand, the situation which has fallen for our consideration in the present case, in the light of Article 16(1), is squarely covered by the decision of this court in Paramjit Singh's case, as clarified by a later decision in the very same case reported in Paramjit Singh. In the aforesaid main case, D.A. Desai J. speaking for a bench of 2 learned judges had to consider paragraph 11 of the report, a recruitment rule which permitted fixing a fixed percentage of posts to be filled up in the given cadre from 2 different sources, namely promotees and direct recruits. Rule 6 of the Punjab Police Service rules, which came up for consideration in this case, provided for a method of recruitment and 2 different sources, 80% by promotion to the rank of inspectors and 20% by direct recruitment. This is the same rule used in the KAS recruitment rules.
Yes.
Examining the working of the aforesaid quota rule for recruitment in the light of relevant rotational scheme of vacancies in the cadre to which recruitment was to be made, the following pertinent observations were made in para 11 of the report. Where recruitment to a cadre is from two sources and the service could prescribe for recruitment from both sources, a question would always arise if the quota rule would apply at the initial stage of recruitment or also at the stage of confirmation. Then, my lords, it is also it is discussed. Last, my lords, in the next page, that hanging part, the quota rule would apply to vacancies and recruitment has to be made, keeping in view the vacancies available to the two sources according to the quota.
Yes,
The quota in this case is, then it proceeds to say what is the quota in that particular case. Next, my lords, after extracting two more paragraphs from the judgment in Paramjit Singh, the aforesaid decision which squarely applies to the facts of the present case, therefore, leaves no room for doubt that when under the recruitment rule 9 in question, there is no reservation of any given category of candidates like SC, ST, OBC to the posts of professors, appointment to the posts in the cadre have to be made in the light of the percentage of vacancies in the posts to be filled by promotion or direct recruitment. The quota percentage of departmental promotees and direct recruits has to be worked out on the basis of roster points, taking into consideration vacancies that fall due at a given point of time. Here, roster would not apply because there is no rota rule incorporated in this. As stated earlier, as the roster for 3 promotees and 1 direct recruit moves forward, there is no question of filling up of the vacancy created by the retirement of a direct recruit by a direct recruit or the vacancy created by a promotee. Irrespective of the identity of the person retiring, the post to be filled by the onward motion of 3 promotees and 1 direct recruit. Consequently, learned counsel for the appellant and learned senior counsel for the intervener were right when they contended that the High Court in its impugned judgment has patently erred in invoking the ratio of the decision of this court in R.K. Sabharwal, which was rendered in an entirely different context for resolving an entirely different controversy, which did not arise on the facts of the present case. They were also right in contending that ratio of the decision of this court in Paramjit Singh, read with the decision of this court in the same case reported in Paramjit Singh, would get squarely attracted to the facts of the present case. Once that conclusion is reached, the result becomes obvious. Whenever in the cadre of professors of ophthalmology, vacancies arise for being filled up at any given point of time, those vacancies in the posts have to be filled by operating the roster in such a way that, that available vacancies get filled by allotting 75% of them to the departmental promotees and 25% to the direct group. Exactly in this way, the roster in the present case has to be operated. The factual position that my lords may ignore, then my lords, at paragraph 12, the other cases dealing with the reservation, that is the Postgraduate Institute of Medical Education, is considered. After extracting 2 paragraphs from Postgraduate Institute of Medical Education, this is a conclusion reached. It is difficult to appreciate how this decision can be of any assistance to learned counsel for the respondent. It is obvious that in the aforesaid case, Constitution Bench was concerned with a similar scheme of reservation for SC, ST and BC candidates. Therefore, Article 16(4) squarely arose for consideration. To that extent, the said decision falls in line with the legal position examined by the earlier Constitution Bench in R.K. Sabharwal. As we have already pointed out earlier, the factual and legal situation in the present case is entirely different. We are not concerned with scheme of reservation Article 16(4). Therefore, R.K. Sabharwal cannot be a precedent to service as seen earlier. If that is so, on the same line, the ratio of decision in Postgraduate Institute of Medical Education Research would also not apply. While deciding the question of working out the recruitment rule for appointment from 2 sources of promotees and direct recruits, wherein only Article 16(1) would hold the field, uninhibited by exceptional category of carved out from the said subarticle 1 by subarticle 4 thereof. The first point for determination is therefore answered in favor of the appellants and against the respondents. Then, my lords, the question, this was about the recruitment. Question of seniority came in the next judgment, that is, my lords, this All India Federation of Central Excise. All India Federation of Central Excise. That is citation 1999, 3 SCC 384. I think if the
But it is not a
spiral binding given is.
It is here in the.
It is
Yes,
there.
page 71.
Yes,
Yes,
page 71.
there is total messing up because paper numbers do not.
Right, right. This is the only one we don't have, Dr. Arun, but.
Yes, my lord, yes, my lord. I am sorry, my lord, sir.
Sure.
You could have been little more.
No, I, probably there was an earlier,
Yes, my lord, earlier it was given and
which
then.
is no longer available in the papers. That may be the reason. Yes,
That judgment, my lords, 1999, 3 SCC 384.
Hmm.
All India Federation of Central Excise. My lords, may kindly turn to para 5. That is at page 74, my lords of that.
yes,
There is the contention placing reliance on R.K. Sabharwal is noticed. Then if the consideration of that particular argument, para 13 to 15 at page 80.
yes,
Reliance by the petitioners is placed upon R.K. Sabharwal case. That case deals with the principle that the post vacated by an officer recruited from SC/ST category must be filled in only by the same reserved category. This is because of the special provision in Article 335 of the Constitution of India relating to adequate representation of SC/STs in the services. The birthmarks there remain even on promotion, inasmuch as a particular number of posts in the promotional category are reserved to be filled in only from among the SC/STs. On the other hand, so far as the normal quota rule between two feeder channels of recruitment or promotion is concerned, be it between direct recruits and promotees or promotion by a quota from different feeder recruits, the relevant precedents are Paramjit Singh Sanghu versus Ram Rakhamal and State of Punjab versus Saran Bhatnagar. In Paramjit Singh's case, which related to recruitment from among promotees and direct recruits, they pointed out that if a quota rule between the direct recruits and promotees were treated as a rule of reservation, then because of the frequent retirements of promotees who are generally closer to retirement, most vacancies would be repeatedly go to the aged promotees, leaving little scope for direct recruitment.
yes,
At page 196, Leonard clarified it follows. What this court meant while saying that when a quota rule is prescribed for recruitment to a cadre, it meant that quota should be correlated to vacancies which are to be filled in. Who retired from service and what source he was recruited may not be very relevant because retirement from service may not follow the quota rule.
yes,
Promotees who come from the service at an advanced age may retire early, and direct recruits who enter the service at a comparatively young age may continue for a long time. It therefore, in a given year, larger number of promotees retire, and every time vacancy referring to source from which the retiring person was recruited, it would substantially disturb the quota rule itself. Therefore, while making recruitment, quota rule is required to be adhered to strictly. Then, my lords, on the facts of that case, it was pointed out that whenever vacancies occur in service, the appointing authority has to go on recruiting according to quota. In other words, whenever vacancies occur, first recruit 4 promotees irrespective of the factors causing the vacancies. And as soon as 4 promotees are recruited, bring in direct recruitment. This is what exactly has been done by the impugned OM Annexure A7. A like situation or what was prohibited by Paramjit was done in is done in this present case. A situation like this arose in R.N. Bhatnagar. Then Malors R.N. Bhatnagar is approved, and it is said that Malors the quota, that is in R.N. Bhatnagar's case, Majumdar J observed as under the quota percentage of departmental promotees and direct recruits has to be worked out on the basis of roster point, taking into consideration vacancies that fall due at a given point of time. For the aforesaid reasons, We are unable to agree with the contention of the learned counsel for the petitioner, Srimati Shyamala Pok. Then, my lords, last but one, last para 22.
Yes.
It may be noted that as long as a particular quota is fixed by a rule, it will have to be followed till the quota fixed therein is altered by appropriate amendment of the relevant rules, not by OM. As held in VB Badami, quotas which are fixed can only be altered by a first determination of the quota. It will be for the applicants to take such steps as they deem fit if they are aggrieved about the existing quota, but the filing of IA is not the proper remedy, etc., etc. The VB Badami was approved here. Therefore, my lords, my responsible submission is, in the light of R.N. Bhatnagar and All India Federation of Central Excise, the consideration of R.K. Sabharwal is out of picture. One, we are dealing with interpretation of recruitment rule and seniority. Then, my lords, the next submission they made was that we are seeking seniority from a date anterior to our appointment. And for that, some judgments are also relied on. And
I don't think that issue is.
I think
I have not even comment, just given the rule, that is all. Even I not comment that argument, not even argued. Today,
or may I say this?
probably he is giving reply, Lord, without our argument at all.
I had almost concluded. Thereafter, post lunch, my lords, I placed reliance on that rule. At that stage, my lords, court felt this rule had to be put to the other side. Whether what do they say? Now, if the reply is only with regard to that on basis of these two judgments, then we'll have to continue our submission.
It is not difficult to answer that.
Lord's final right to reply. Maybe
I have not comment my argument.
Very well, ma'am.
Their arguments definitely have to be heard.
Let
Let that be concluded, then we'll come back.
very well.
Or if sir
I'm
is
grateful,
finished,
ma'am.
reply will continue.
Well, I think
Yes, after they had the additional advocate general had been heard. Then, yes.
Which do not have overriding effect. That the other side has not. But anyway, I think that to the forum.
Yes.
But one thing is certain. This service jurisprudence is more confusing than what any other jurisprudence.
Well, that is a matter of opinion, is all I can say.
All these people who are on the service will not agree with me.
no,
Well, you have another on that side.
it is. I agree with you. It is lawyer's law than any written law.
Seniority law is laid on 1976. Till today, Lord, we are fighting the same issue.
Yes. Yes.
The question is whether it is vacancy based or post based classification. The Lord will find
Yes.
the question is whether, my lord, state government can issue, Lord, executive instruction to fill up the gap if there is a loophole in the, Lord, rules of recruitment. My lord will find page 1, the first recruitment rules of, my lord, Mysore Administrative Service recruitment is 1957. My lord will find the schedule 2B.
Yes.
Conditive law. All class 1 junior scale post. Now it is called not group A junior scale. That's all.
Yes.
Conditive there, not how it is worded there. 66 2/3% of vacancies to be filled by promotion. Kindly note it. Vacancies to be filled up by promotion, by selection from class 2 officers. Then my lord, 33, next page, 33 1/3% by direct recruitment competitive examination to be held by Public Service Commission. So, the word enumerated in the rule is vacancies.
Yes.
This rule, Lord, is, Lord,
Yes.
so far as Lord 1957 rule post filled, it is the vacancy alone. Classification is based on not post vacancies. But this 1957 rule, Lord, is amended in 1994. When it takes page 4, Lord.
Yes.
That argument is not. 1957 still holds the field. It still holds the field, not yes, they are correct. It's factually incorrect. Why? Because in 94 itself, Lord, the rule is amended. And we take page 4, Lord, the title and commencement. These rules will be called Karnataka Administrative Recruitment Amendment Rules. Administrative Services Recruitment Amendment Rules 1994. Kindly take, Lord, directly page 6. And it's even Roman 2 also. It's very important. Why? Because all class 1 junior scale post at serial number B, the following shall be substituted, namely class 1 junior scale post blood. That is referred in the 1957 rule B, page 1, rule 2B. Kindly note it. Rule 2B in 1957 is now substituted. That is called now designated as KAS Group A Junior Scale. But how does it is worded here? 50% by direct recruitment in accordance with the Karnataka Recruitment of Direct Provision, appointment by competitive examination rules 1966. Then what? 2. 50% by promotion from the first in that. The word vacancy is wiped out.
All class 1 junior scale posts at serial number B.
Yes.
The following shall be substituted.
Substituted.
KS Group A junior scale.
Yes.
50% by direct recruitment in accordance with Karnataka Recruitment of Gazetted Probationers Appointment Rules, and 50% by promotion from the cadre of Tahsil.
Now, this is a rule which was existing when petitions are recruited. And when you were here the word, this rule is not produced, not brought to the notice of this court.
Yes.
But Supreme Court in B.B. Badami was state of Mysore interpreted 1957 recruitment rules, where recruitment provides vacancies 66 2/3 by promotion vacancies and 33 1/3 vacancies to directed. So interpreting that rule, the Supreme Court.
Kindly, Mr. Bhagwat, can you adjust your microphone? Sorry for the interruption.
Yes, sorry. 1957, the concept of vacancy was there. Till 1994, for recruitment to the post of KAS, Group A junior scale. Earlier it is called class 1. Kindly see how it is worded in 1957.
Yes.
Page 1. 66 2/3% of vacancies to be filled up by promotion, by selection from class 2 officers. So, word 66 2/3%, the vacancies is the importance. But whereas in 1994, the concept of vacancies vanished, is wiped out. It is silent. Now, my lord, page 6, my lord. Am I audible, my lord?
Yes.
Yes, you went to the next court.
Yes, page 6, my lord. 1994 rules, my lord. Yes, my lord. Case Group A junior scale, 50% by direct recruitment accordance with the Karnataka recruitment of gated provisioners, appointment by competitive examination rules, 1966. 50% by promotion from the cadre of Tahsildar grade 1. Here, the concept of vacancy is not wiped out. Vacancy word is not there. But again, my lord, this 1994 is repealed. Kindly take note further, page 7. Kindly see that also.
Yes.
By which time, my lord, petitioner were already recruited. We are already promoted. But why I am bringing notice of this court? Because the concept of vacancy was not there after 1994, even in 2018 rules also. Kindly take note, page 7 now. Coming to the page 8, the last, Lord. B.
Yes.
Case Group A junior scale, 50% by direct recruitment in accordance with the Karnataka recruitment gated provisioners, appointment by competitive examination rules 1997, and 50% by promotion from the cadre of Tahsildar grade 1. Not here also, Marat. It is very silent. Rule is silent. Whether vacancy or post, Marat. From 94 onwards, this. There is no, not either vacancy or post is not there. Then how to interpret? Whether in such a scenario, whether state can, Marat, issue executive instruction to fill up the gaps in the rule is a question, Marat.
Yes.
According to me, Marat, certainly state has power to issue executive instruction to fill up the gaps in the rule, which will be supplemented by the executive instruction.
Then if it is vacancy, if executive orders is post-based, then state cannot.
Suppose, Marat, 1957 holds it today. If it is there, we will forget 94 amendment, 80 amendment, as if it was not there in the statute. Then, my lord.
Your contention is that because of the amendments,
Yes.
the words vacancies having
Taken away.
not being continued.
Yes.
Therefore, as to how the quota is to be worked out is a matter for the state to issue executive instruction.
Executive instruction.
That is all that
I am
is being
supported by Lord CH-3 versus High Court of Kerala, and Lord, which is latest decision of the Supreme Court, is reiterated the Kerala judgment. As far as that is concerned.
Yes.
Not I will submit the first. I will not finish my argument. Then
Yes,
Lord take
please.
citation.
Please.
Not page 9 is the impugned blood circular executive order issued by the state government to adopt blood post-based blood classification, nullifying the blood the government order issued on 5/7/1976 as per blood Badami's case, and which is reiterated in Gonal Biompa's case. This 23/2016 blood is very clear, Lord. Preamble of the order itself would indicate, Lord, why they are issuing this. Now, before coming to that, Lord, the what Constitution says is very important. Kindly take, Lord, for a moment.
Constitution.
The provisions of Article 16.
Yes.
But Article 16(4) and 4A.
Hmm.
Nothing in this article shall prevent the state from making any provision for reservation of appointment or posts. Kindly note it, appointment or posts. Then, my lord, in favor of any backward classes citizens, which in the opinion of the state is not adequately represented in the service under the state. The word referred is post only. Then, my lord, I kindly see again 4A. 4A was introduced, my lord, in the year, my lord, 95.
4 and 4A are with regard to reservation
Lord,
as provided in 15, Article 15(3).
But Indira Sahni's case, my lord will remember, Supreme Court observed, there was no reservation in promotion, Constitution will not provide. To abrogate that, my lord, this was introduced. But
Correct.
the question is,
The reservation, what we are considering here is not a question of reservation at all. It is only method of appointment.
yes,
16(4), subject to correction, does not come into the field picture at all.
No, I'm only saying, my lord,
Yes.
to show that 4 and 4A both refers to post only. Promotion and direct recruitment both refers to post only. Nothing else. To show that, my lord, I'm reading. So concept of vacancy is not there in the Constitution. It's only post. And you see 4 and 4A also.
It's not for the Constitution to provide for
No.
reservation as to,
No, I'm not saying.
that has to come either in the recruitment.
But
rules
state
or-
has issued executive order in state of Karnataka on 27/4/1978, reserving 15% of post for FC in
Correct.
promotion and not 3% for ST. That has been now recently enhanced, my lord. No, my
Yes.
lord. Question now is recruitment rules
Correct.
provides that, my lord. I have no case. If recruitment doesn't provide, the only question is filling the blanks. Lord, now, impugned order, my lord, page 9,
Yes.
subject.
Mm.
Filling of KS junior scale posts by post-based classification instead of vacancy-based classification. The state government has issued guidelines, so and so, dated 5/7/76 and so and so 14/12/87 for calculating the quota to be filled by direct recruitment promotion as prescribed in the respective cadre based on the vacancies. Correct. The government has decided to revise the method of calculating the quota for direct recruitment and promotion in KS junior scale. Accordingly, following guidelines are issued. Number of posts to be filled up by direct recruitment and promotion shall be determined and appointment shall be made based on the total cadre strength of KS junior scale, depending upon the quota prescribed in the cadre and recruitment rules. The appointments either by direct recruitment or promotion shall be made against the percentage number of posts determined for the respective quota. Direct recruitment shall be appointed against the number of posts determined for the direct recruitment quota, and the promotees shall be appointed with the number of posts determined for the promotion quota. As long as quota rule remains, neither the direct recruits can be appointed against the post in promotion quota, nor promotees can be appointed at the post in direct recruitment quota. But how they have given example, what, at page 10, how it should be calculated. Post-based, post-based classification.
Yes.
Kindly see, my lord, annexure example. But this is factual aspect where, Lord, the table is worked out. It is referred as an example in the annexures.
Yes.
Lord, working strength, they show, my lord. Page 10, my lord. 33 direct recruitment, 93, promotion. Vacancies to be filled up in accordance with the vacancy based classification, 189. Promotion, 0. Now, kindly see, quota to be earmarked based on post-based classification. Kindly note it, 157 and 158. Then, my lord, vacancy position based on post-based classification, 124, for promotees, my lord, 65. Because 93 is already utilized, post is utilized, working time.
Yes.
If you take post-based, vacancy-based classification, not promotion is concerned, 0. If you take not post-based doctrine, not vacancy, post will be 157, 158.
And
158
vacancy-
minus 93 will come to, my lord, 65.
Yes.
That's all the simple calculation, post-based. What is wrong in it, whether state has power or not? Then, my lord, this is only for KS. This broad impugned broad order, circular 233616 is only for KS junior scale, not, my lord, all other, my lord, cadres in the state, civil Karnataka state. Not Karnataka state also, but first another notification, page 21. It is in Kannada version is there. Not it commences 11. English version is page 21. But kindly see this. But why I have produced this notification? Because one of the ground is, my lord, that it is only applied to KAS junior scale, not the other cadre in the state civil service. Was the, my lord, argument addressed? As on the date. Yes, as on the date, they argued is correct also. I don't, my lord, dispute. But
Yes.
in 21, my lord, they issued a general notification applying post-based doctrine in all state civil service. All the posts in state, wherever the quota is prescribed for DR and PR, it applies to all.
Would that be legal? Would that be legal if your now contention is that because the rules have been amended, taking away the concept of vacancy
Yes.
based, it is open to the state to say that it is post-based because that word vacancy is there, not there in the amended rules, therefore the state. Is it open to the state to pass an executive order
Yes, my lord.
as a notification, saying that wherever it is, whatever it is stated in the current recruitment rules, it will be, all quotas will be operated as against posts without amending the rules? Is it open to the state to say so?
No.
Just,
They have contended, my lord.
they are not considering that.
No.
question.
Lord, they
I'm
have,
only asking.
they have contended, my lord. The only post-based doctrines applied in KS junior scale, not other cadre in the state civil service. There was an argument.
Only because it
For
is
that
brought-
purpose, I am producing, nothing else.
Because it is brought to our notice, we are asking you,
Yes.
is that permissible? If the current recruitment rule says vacancies,
Yes.
after the decisions of the apex court with regard, is it possible?
State cannot. My lord is right. Since, my lord, cadre and recruitment doesn't specify anything, my lord,
Correct.
would it be permissible to supplement by issuing executive instruction?
Was this the argument of the state before the tribunal?
No, my lord. It was not argued.
Was that the argument before the tribunal?
And
Because
Before the tribunal, the argument was advanced. It was pointed to the tribunal that government's files disclose that the opinion of the government was amendment to the rule is necessary. Accordingly, they amended the general recruitment rules, giving it overriding effect in May 2015. Then there was protest from backward classes federations.
correct, that you have shown us,
Yes,
general recruitment.
yes,
And it was
stating
been-
that if quota is linked to posts, there will be reduction in direct recruitment opportunities. We will not be able to serve the government. Then they withdrew the rule in November 2015, restoring the vacancy-based quota for
We-
promotion,
We are just
for
asking,
appointment.
was this the fact that the junior scale, the rules relating to Karnataka Administrative Services recruitment rules being
Not brought to the-
amended, taking away
No, no.
the concept of
Let's-
vacancy?
No, my lord. No, my lord.
Therefore, it is only a lack.
That was not argued. The only reply of the state at para 7 of its reply statement was, Sabharwal has come, therefore we have done.
Lords, I'll just.
Only. for
Notwithstanding Sabharwal or not, whether state can fill up the gaps or not.
Lords,
If
I'll-
Sabharwal decision is not there, for
This
example.
was not.
It is being considered for the first time here.
For the first time.
Yes.
Yes, my lord. My lord is considering the question of law, my lord, can decide here itself.
Just clarify, my lords, before the
Yes.
tribunal,
Yes.
defense of the state was, on what basis, my lords, we brought about the 2006
Correct.
circular, which
Correct.
we provided for post-based and vacancy-based, 2016 circular. Then, my lords, our argument was considered, and it was upheld. My lords, their argument before my lords has been that the rule position as existed,
Right.
and
Exactly.
that, and on the basis of that, my lords, we were trying to respond, and then in response to that, on the last date of hearing, my lords, during lunch hour, my lords, we were
Yes,
able to reach it.
This suddenly, which is
This-
why I asked, this was
No,
never
this was
the,
never considered. My lords are now
No,
considered.
no.
And not only that,
I must be thankful to my learned friend because he has produced the 2018 rules. In the 18 rules, my lord,
It's a
there is a
reference to-
reference of 94 rules. That is why, my lord, I immediately came to my mind whether, what does 94 rules say?
if a pure question of law, we may have to consider, it has to be
Yes.
considered at any stage where it is raised.
that is one aspect. But
Fairness,
today, my
date
lords,
to
in
the-
response to what happened on the last date of hearing,
Hmm.
the court felt, my lords, that notification should be put to them and a copy was served to them. Now, my lords, they have advanced an additional argument today on the basis of the later two other judgments of 1999. Only on that, my lords, we may be permitted.
It has no application. That, my lord, there are no such rules are there, my lord.
Consider,
Particular
yes.
facts of this case are entirely different than the Butler case and other case, my lord.
Yes,
It has no application at all. Now, my lord, page 21 is the, my lord, general, my lord, instructions issued by the state government applying the post-based doctrine to all, my lord, department, page 23, para 5.
yes,
In the background of above explanations, the method of classification of post in cadre and recruitment rules in specified ratio for the direct recruitment for promotion based on vacancy classification method in case of state civil service post is hereby cancelled. Hence, in order to recruit or appoint adopting classification based on post notification that so and so and so cited above reference are bit modified and the below guidelines are provided. But then, my lord, guidelines are provided, then, Lord, it gives page 26, my lord. It gives, Lord, illustration of that circular of, Lord, 2016 circular illustration is given how it should be post-based doctrine will be applied while calculating the quota. Same, my lord, illustration. Kindly see, my lord, that also.
Is given, is taken as example here.
How to apply, Lord, post-based doctrine is whatever done in that circular, actual. Lord, same is applied, same example is taken, how to do it, how to classify it. As an illustration, it is called out here. Therefore, my submission to your lordship, that question will never arise now. It applied to all of Lord. That too prospectively.
yes,
So these are the, Lord, enactment and government orders.
yes.
Petitioner that after 1957, rule is 2018 is actually incorrect.
Lord, after 1957 rules, 94 rules came into force. Then, Lord, 18 rules came into force. But they have produced 2018 rules. But There was an amendment in 1994, which is not brought to the notice of this court at all.
Even in the 2016 circular, the state does not refer to the name.
No, my lord. Certainly, my lord, that also doesn't refer it. No, nowhere. But the question is now, my lord has to, my lord, interpret. If the rules are silent, whether, my lord, government has power to supplant the, my lord, rules by way of issuing executive instruction is the question. Lord, the first proposition is, my lord, computation of seniority based on post, not vacancies. Lord R.K. Sabruwala, para 6 is, my lord, I do not read again. They interpret what is vacancy, what is, my lord, post. Lord,
Post to create a vacancy is the ultimate finding.
the finding in para 6 is, my lord, there must be post first to create a vacancy. If posts are not there, no vacancy. Therefore, Supreme Court introduced the, Lord, concept of post. There can't be two yardsticks while maintaining for roster one my lord, concept. One concept for, Lord, recruitment between DR and PR. But reservation is concerned, it will apply to both PR and DR. Admittedly.
Reservation, you take the yardstick of post-based.
Reservation is concerned, Lord, it applies to both. While recruiting, they have to apply reservation. While promoting also, they have to apply roster. There cannot be two yardsticks. One post-based, Lord, one, Lord, vacancy-based. Unless, Lord, recruitment rules provides.
Exactly.
Unless recruitment rules
The recruitment rule provides.
provides, Lord.
Vacancy, I mean, where reservation is being, communal reservation or caste-based reservation is being operated, it can only be to the posts,
Yes,
the
ma'am.
fixed cadre.
Yes.
But if the cadre, I mean, the cadre and recruitment rules specify that the method of appointment, where there are two sources of appointment, and the quota is to be operated between the sources of appointment. And if the cadre and recruitment rules specifically provide that the quota is to be operated as against vacancies, then there can be two rosters. There's
Yes.
nothing wrong.
Permissible.
Because this is not a roster under 16.4 at all. It is only a
So,
method of appointment,
yes,
two sources, how it is to be done.
yes, my lord.
The
Yes.
contention that it cannot be unless
So,
the
correct.
last sentence is
Correct.
decisive.
Unless, my lord,
Unless the.
that is
rule
why, my lord,
Correct,
I added adjective.
correct.
Kindly see, my lord, the para 6 in, Lord, page 6 in Sabrawala's, only
Yes,
one
we-
paragraph I will read. I don't read it, my lord.
We've seen.
I-
paragraph
But
6.
I don't, again,
Yes.
Lord, because only to show that what is vacancy, what is post.
Correct.
Then, my lord, it has been reiterated, my lord, next case. V. Lakshmikantan, another. Lakshmikantan and another versus Union of India. Same reiterated. my lord.
Yes.
Next one is, my lord, CH-3 versus High Court of Kerala. My lord was asking judgment only last occasion. This judgment, my lord,
Appointment of municipal magistrates.
correct. Where, my lord, there was a gap in the rule. That my lord knows. But para 62, my lord might have read number of times this judgment. I don't read again. Para 62 is will answer this. Para page 48, para 62. Thus, it is seen that apart from the amplitude of the power under Rule 7, it is clearly open for the High Court to prescribe benchmarks for written test and oral test in order to achieve the purpose of getting best available talent. There is nothing in rule barring such a procedure from being adopted. It may also be mentioned that executive instructions can always supplant rules which may not deal with the every aspect of the matter. Even assuming the Rule 7 did not prescribe any particular minimum, it is open for the High Court to supplant the rule with a view to implement them by prescribing relevant standard in the advertisement for selection. Reference may be made to the decision of the this court in state of Gujarat versus Soils. That's all. Then, my lord, benchmark, printing benchmark. That's nothing else. Benchmark stay. Administrative order can be made. Then, my lord, latest judgment of Supreme Court in my lord, Dr. Kavita Kamboj versus High Court of Punjab, Haryana is the latest judgment on this point, referring to the my lord Siraj case. 2024-7 SCC, page 103, para 70.
Para?
70, page 102. 102.
Yes. Yes.
Page 48. Page, my lord, page 92. 92, my lord. Question, my lord, is whether rules can be supplemented. Page 92, my lord.
Yes.
The rules can be supplemented to fill in gaps is a question. My lord, there, my lord, referring to several decisions, my lord will find page 54 or para 54. Page 94. Page 94. Particularly refers to, my lord, the case Siraj was High Court of Kerala. The particular paragraph 62 is called out. Then, my lord, answer is, my lord, ultimately, para 70.
All the decisions referred to there, including the present one,
Yes, my lord.
are with regard to judicial appointments.
Here, my lord, word vacancy is missing, whether post or vacancy, my lord. State has always been filled up.
I was just remarking.
Yes.
that all this judgment as well as all the
Yes, ma'am.
judgments referred to are with regard to judicial appointments.
Yes, my lord, judicial appointment too. I'm only citing because the
No, it was only a remark. Nothing else. Yes.
para 70, my lord, is my lord which answers the question. In numerous decisions, this court has emphasized the importance of control, which is violated by the high courts over the district judiciary. Undoubtedly, it is equally well settled when the rule under 309 hold that field, these rules will have to be implemented. Where specific provisions are made in the rules framed under Article 309, it would not open to the High Court. It would not be open for the High Court to issue administrative direction, kindly note it, either in the form of full court resolution or otherwise that are inconsistent with the mandate of the rules. On the other hand, in cases such as one at hand where rules were silent, kindly note it, it is open to the High Court to issue full court resolution. The High Court did so initially on 29, but modified the resolution on 30/11/21 by prescribing candidates for appointment to the higher judicial service should have minimum 50%, both in the written test as well as in the independently. The wisdom of the prescription is clear. Candidates should not just demonstrate the ability to reproduce their knowledge by answering questions in the suitability test, but also
Was also.
It's a larger decision, my lord.
Just a moment, just a moment. Yes, 2024, 3, SCC 799. Shivanandan CT versus High Court of.
Yes,
Appeal.
yes.
That was a case where the departure from the prescribed notification was frowned upon,
Yes.
but the selection was not interfered with only because they'd already been appointed as
Yes, yes.
district judges and
Yes.
were.
That is, my
performed
lord,
the duties.
page 95, Roman 3, Shivananda city. It's also referred.
After 6 years, you can't touch.
Only
No.
for that reason, the entire selection was found faulty
Supreme Court,
because there was a
The appointment.
superimposed condition during the selection while it was on. There was a decision taken that there would be a cutoff mark fixed for the interview, which was not there in the rules.
yes,
It was considered, it was found against very strict
principle of
strictures were stated, but for the reason that they were actually selected, were continuing for 6 years, was not touched.
equity is extended under 141, my lord.
Yes,
No, para 70.
yes,
In numerous decisions of this court, has emphasized the importance of the, Lord, this I have read, my lord, a candidate should not just demonstrate the ability to reproduce their knowledge by answering questions in the suitability test, but also demonstrate both practical knowledge and the application of the substantive law in the course of the interview. The rule being silent, it was clearly open to the High Court to prescribe such criterion as it did in 2013 when 50% cutoff was prescribed on aggregate scores, and also in 2021 when the 50% cutoff was prescribed in the written test scores and viva versa separately. Then, my lord, conclusion. I upheld the judgment of the Haryana High Court. We have therefore come to conclusion that state government was plainly in error in finding fault with the process which is being followed by the High Court, and in concluding that decision of the High Court amounted to arbitrary exercise of power, though Solicitor General pointed out that expression arbitrary and betrayal of just trust were used in communication of the state government, placing reliance on the earlier judgment of this court. We would leave the matter at that while affirming the conclusion of the High Court. For the above reason, my lord, so on. My lord, in that Haryana judgment, my lord, rules were silent how to, my lord, aggregate the marks. Resolution was passed and instruction is issued to fill up the gaps. My lord, accordingly, appointments are made. Therefore, my lord, executive instruction can be issued, supplement the rules which state government has done it. Then, my lord, yes, yes. The page 106 onwards, my lord. Proposition is, my lord, no appointee from anyone can claim seniority from the date before his appointment. But they are appointed in the year. Why I am citing this, my lord?
no, there is no question of their claiming seniority on any earlier date. The direct recruit seniority will come into operation only from the date when they are
Yes.
appointed for the first time to the service. The only question is, how is the seniority to be inter se decided against between direct recruits and promotees?
Yes,
That is
yes.
all. they cannot claim seniority on any
To
earlier.
that
date.
extent, I'm only relying upon decision of this.
I don't think anybody has has an objection to that proposition.
Yes. Yes. Will be better. Will be better.
Question would only be this.
Yes.
If it is within their quota, then whether
Yes.
you can claim seniority on an
Yes,
earlier
yes.
date. That is all.
While working out the post-based doctrine,
Correct.
if the promotees are excess, my lord, they should not yield to the direct equities.
Yes.
My lord, may kindly take page 164, my lord,
Yes.
regarding delay.
Yes.
Regarding, my lord, vacancy,
Yes.
whether they can, my lord, claim the quota from the rate of vacancy or
That might lead to absurd situations. There was a decision of the apex court. I think it was in the excise department, where a situation was pointed out. If the date of vacancy is to be given in the case of direct recruits, because direct recruitment did not happen for a while. And then if the date of vacancy is to be given, one appointee would be given a date before he was born. That was, if that was a date to be reckoned, it would lead to a situation where he would get a date before he was born.
yes,
If
much
this-
prior to his birth, he would get.
Yes,
Pyara, my lord, page 164. Page 164, my lord,
yes,
Pyara 80. We have next to refer to one other contention raised by the respondent, direct recruits. They claimed that direct recruits appointee can be antedated the date of occurrence of vacancy in the direct recruitment quota, even if on the date of the said person was not directly recruited. It was submitted that if the promotees occupied the quota belonged to direct recruitees, they had to be pushed down. Whenever direct recruitment was made, once they were pushed down, even if the direct recruitment came later, he should be put to direct recruitment slot from the date on which the such slot was available under direct recruitment quota. This contention, in our view, cannot be accepted. The reason as to why this argument is wrong is that service jurisprudence, direct recruitment can claim seniority only from the date of his regular appointment. He cannot claim seniority from the date when he was not born in the service. This principle is well settled in so and so and so case. They quote blood. Then blood comes to conclude that blood they cannot be. It cannot be possible to not give anterior to their birth. Anterior to their appointment, if
Then
that is implemented,
A. Janardhanan was Union of India. It was held that a later direct recruit cannot claim seniority from a date before his birth in the service or when he was in school or college.
college.
Yes,
A. Janardhan, in fact, is more of seniority only. It is in the representative capacity where the question was whether or not all the appointees should be implemented or promotees should be implemented. Then the court said no, only representative capacity is a principle that is sufficient. Lord, last decision is regarding delay. Lord, 2016 circular. Impute circular is 2016, March 2016. Lord. 23/3/2016, they
Yes.
filed Lord application 2019.
yes.
Their appointment was 2017. Kindly note it. (23/3/2016) is the impugned Lord, order, which was challenged before the Lord, Karnataka Administrative Tribunal. They were appointed on 16/9/2017. Lord, application is filed before the State Administrative Tribunal in the month of Probably, my lord,
2019.
2019. But they are only not only guilty of blood or delay. Their objection is, my lord, delay is condoned. Therefore, tribunal ought not to have dealt the subject of delay. Tribunal never said, my lord, delay is condoned. It noted it, but delay is condoned. Laches cannot be condoned. It's a principle not adopted. But delay is different. Laches are, my lord, later form.
Yes.
In this case, my lord, paras 16 and 17.
Yes.
Page 175. Thus, doctrine of delay and laches should not be lightly brushed aside. A writ court is required to weigh the explanation offered and the acceptability of the same. The court should bear in mind that it is exercising an extraordinary and equitable jurisdiction. As a constitutional court, it has a duty to protect the rights of the citizens, but simultaneously it is to keep itself alive to the primary principle that when an aggrieved person, without adequate reason, approaches the court at his own leisure or pleasure, the court would not be under legal obligation to scrutinize whether the lease at the belated stage should be entertained or not. Be noted, delay comes in the way of equity. In certain circumstances, delay and laches may not be fatal, but in the most circumstances, inordinate delay would only invite disaster for the litigants who knocks the door of the court. Delay reflects inactivity and inaction on the part of litigant. A litigant who has forgotten the basic norms, namely the so and so, is the greatest thief of time, and second law does not permit one to sleep and rise like a phoenix. Delay does not bring in hazard and causes injury to lease. In the case on hand, there, my lord, 4 years delay. Here, my lord, 16th official memorandum, they were appointed 17. 19, they approached it.
Yes.
There is approximately, my lord, 2.5 years delay in approaching the court. Therefore, my submission to your lordship is, my lord, both on two principles, post-based, even the decision under which Sabruwala case is not there, state has power to issue executive instruction if the rules are silent, that they have issued. Therefore, my submission to the lordship is, synopsis will be given to the court officer, my lord. With synopsis will be sent to the there also, my lord.
Please.
With
The
a copy to my
revised- The revised synopsis on the basis of the.
Yes. 16/11/2019 is the date of filing of the application.
Yes, yes, all that is.
I am very grateful, my lord.
So far as mine is concerned, next week I will. But what exactly, my lords? The effect of the circular, if it is read, I'm sorry. 23/3/2016 circular. Last time I made a submission. The effect of it, my lords,
Just
if your lordships would
just for
take,
clarification, in which of these matters are you appearing and for whom?
for respondent, my lord, two respondents.
34 and 40. 3417.
Yes, 3417. Are 34 and 43? Yes. 40. Yes,
If your lordships take 23/3/2000 impugned government order.
Hmm.
Of course, I am only just giving in 2-3 sentences clue. What is the scope of a dispute or a controversy in these cases? That this GO is reiteration of 5776 and 14/12/87. The earlier two government orders. The earlier two government orders.
yes.
Now, my lord, the crux of the matter is only class 4. I just wanted to appeal to your lordships, my lords. Class 4,
Yes,
if lapsing of vacancies is only in respect of the direct recruitment, then they would have been aggrieved. Lapsing of vacancies as on the date of 23/2016 is for both the source of recruitment. I will just read formulas. The unfilled quota, my lord, 1, 2, 3, they reiterate the quota rule. There is no alteration. They reiterate the earlier 5776 and 14/12/87 government orders. They say quota rule has to be upheld. You can't, one quota, one source of recruitment cannot claim the seniority against the other. All these they reiterate. But the crux of the matter comes only on 4.
no, 1 and 1, 2 and 3 also.
Pardon
They-
that?
1, 2 and 3 also. They say the number of posts to be filled up by direct recruitment and by promotion shall be determined and appointment shall be made. based on the
Total cadre strength of the KES,
Correct.
correct. The number of posts to be filled by DR and promotion shall be determined based on the total cadre strength. When quota is, my lord, when more than one source of recruitment, if the quota has to be determined only based on the cadre strength, not on the vacancy strength.
Yes,
Quota has to be determined based on the total cadre strength. Then, your lordships are reading that.
yes.
Then,
Clause 2 says
uh,
appointments either by direct recruitment shall be made against percentage or number of posts determined for the respective quota.
the number of posts and the promotion shall be determined based on the total cadre strength, juniors, depending on the quota prescribed in the cadre and recruitment. Nothing is changed in quota rule here.
Hmm.
Now, next. The appointments either by direct recruitment or shall be made against the percentage or number of posts determined for the respective quota. Quota is reiterated. Next. The direct recruit shall be appointed against the number of posts determined for the direct recruitment. Promotee shall be appointed against the number of posts determined for promotional posts. They reiterate then. So long as the quota rule remains, neither DR recruits can be appointed and so and so, then rule 17 of the general recruitment.
The only difference that is made is from vacancy, this says quota, posts. That is
Yes,
the difference. That difference is there. We cannot close our eyes to that difference. The answer would be that it does, the rules do not, cadre and recruitment rules do not
Malan,
say either cadre.
the
and
work,
Either vacancy or post, therefore it is open for the state to say.
my lord,
post.
quota is determined by the recruitment rules.
Correct.
Quota is always determined qua the cadre strength in a cadre.
Cannot agree.
Pardon, lord?
That cannot be agreed. If the cadre and recruitment rule says vacancy for the purpose of operating the quota, then it has to be vacancy.
That we will,
The
we will-
contention that it is only against.
next I will submit.
Yes. Yes, no,
The
let us.
quota is always determined by recruitment rules.
Correct.
The total number of posts you are dividing between the two source or three source of recruitment is again with reference to the cadre strength. That is the total number of posts of a cadre.
Does not have.
Third, I will submit. That is third. So far as the working out of the quota, how do you determine the seniority is now controlled by the two government orders.
Mm.
5776. That is why I wanted to throw a clue how we can proceed in the present controversy. Determination of a seniority, working out of the quota,
Mm.
is now regulated by two government orders. This government order is nothing but a
Yes.
furtherance of further guidelines to maintain the quota. Otherwise, you can't determine the seniority.
Yes.
Therefore, according to me, my lord, if your lordships kindly take 4, clause 4, I wanted to read.
Mm.
The unfilled quota
Yes.
calculated and treated as a shortfall, either in favor of the director recruits or in favor of the promotees, according to the rules of recruitment in force prior to this date shall lapse. Now, those vacancies which were available unfilled as on 23/3/2016 would lapse. Unfilled vacancies from both the quota. If suppose, my lord, the vacancies of only direct recruitment is lapse and not the promotee, there would have been a voice of the discrimination. Then, the posts which may be filled after the commencement of the said amendment rules shall be so filled after determining the share of the quota strictly according to these rules from the source against which they are reckoned. Now, again, my lords, the filling of the vacancies from as on 23/3/2016, the quota will follow. Now, what is the effect of this lapsing of vacancies which are unfilled
Yes.
from both the groups? Then exception is scheduled caste. Now kindly go to millets. Five, when a direct recruit vacates the post in direct recruitment quota, it shall be filled by direct recruitment only. Similarly, when a promotee vacates the post in a promotional quota, it shall be filled by promotion only. In exceptional circumstances due to exigencies of administration and for reasons to be recorded in writing, independent charge arrangement may be made against the direct recruitment. As soon as the die is done, the independent charge shall be withdrawn. The services rendered against such independent charge arrangements neither counts for seniority nor gives any right for promotion to the incumbent against the post in which he is placed an independent. My lord, these are all exposition of law. So, whenever an ad hoc promotion, you can't reckon the seniority is the settled law that has been paid. The only extra guideline is added, my lord, would be 5. Consequence of 4. Again reiterating the quota. Now, this is, if your lordships kindly see, the first paragraph, the state government has issued a guidelines dated 5/7/76 and 1412 for calculating the quota to be filled by direct recruitment promotion as present the respective cadre rules based on the vacancies. Now, how a seniority has to be determined so far as the Karnataka is concerned, after Gonal Bhimappa Mallards and after Badami's case, general guidelines is regulated 5776 and 141287. That is reiterated. These guidelines are further guidelines about lapsing of vacancies which are unfilled as on 14/12/1987. And this lapsing is towards the uniform policy from both the groups. Now, beyond this, there is no modification. Quota is different, seniority is different. You will have to maintain the quota. If quota lapses, seniority will lapse. Seniority cannot be worked out at all, but I will make a submission on that. This small addition of class 4 is only a departure of the two guidelines. Now 5776,
The earlier guidelines specifically said that the quota would be operated as against vacancies.
pardon that?
The earlier guidelines specifically said that the quota would be operated as against vacancies.
Correct.
Were the earlier guidelines. Just a reading of the first part of this OM will show that there is a departure, and that what is intended is that the quota will be operated henceforth against posts. Henceforth. The working out of the quota as against vacancies will cease. All the vacancies which are available for both the groups will also lapse. And from the date of
Unfilled,
the
unfilled.
unfilled, the vacancies,
Yes.
this is exactly what I said. The vacancies will lapse. And from 23/3/2016 onwards, it will be, the quota will be operated as against the posts and taking note of the vacancies as available in
Respective quota
the respective
as per
quota
the cap.
applied to posts.
Correct.
Yes, this we understand.
That's the modification.
No, to say that there is no modification may not be correct. That is all I said.
No, according to me, Millets, according to me, there is no major of course, Millets, subject to your lordships are. There is no major departure. Why this circumstances has come when the quota is breached? You can't determine the seniority. There is a total lapse of quota, then you can't determine the seniority. Therefore, what should happen to the vacancies which are unfilled as on a particular date?
Senior Counsel, are you on the principle of breakdown?
Pardon that?
Are you on the principle of breakdown of the quota rule? Breakdown?
Yes, Millets.
For breakdown, there has to be better pleadings and materials.
That is the main argument. That's the main argument.
For breakdown, what has been pleaded and what has been placed on record may not be enough, is prima facie. For breakdown, there has to be much more than this. It has to be specific case of breakdown. And there must be material to show that breakdown. From what is pleaded and what is placed on record, breakdown does not appear to have been brought out in this case.
There is a more than 4 to 5 years gap so far as the recruitment is concerned, as is evident from the calculation of.
Maharashtra Engineers Association case said, just a delay in making the direct recruitment.
No,
is
beyond
not
1 year, quota is breakdown. That's a law.
Let's see.
Maharashtra's case, beyond 1-2 years, that's the Lakshman Rekha. Quota rule is breakdown. If quota rule is breakdown,
Much water has flowed under the bridge
yes, ma'am.
after that. 1 or 2 years delay in making direct recruitment is not breakdown.
Once the quota rule, my lord, if it is inoperative,
If it
then
is
there is no
inoperative-
question of application of seniority.
If it is inoperative, I agree. But for the inoperativeness of the, or the breakdown of the quota rule, much better pleadings and much better material has. to
Of
be
course, my lord, why I read, my lord, this government order, the controversy, my lord, where does we stand so far as this controversy is concerned? What exactly in substance, the 23/3/2016 modifies or there is a departure of earlier executive two policies, 5776 and 14/12/87. I'll just make submission.
Additional Attorney General, shall we continue or do you want to?
Please, I'll just use the mic first because
Brother, what do you say?
it's just.
Madam?
What do you say? Whether the further arguments shall we hear?
No, it's only on
Okay,
this,
so
my lords. I had almost completed my argument and I had.
We'll
made a-
hear the Additional Advocate General also
Yes,
and close the reply so that we can go to the rejoinder on the next day.
yes, yes.
I will proceed.
You also want to?
Yes, and I just am replying, my lords, I had completed my argument and my lords, I had also stated that I'll be filing my written short
Yes.
synopsis.
Yes,
But now in view of the submission that they
Correct.
have made
correct,
on 99 my lords,
correct.
it's a slightly different kind of argument based on, because if that interpretation is there, then you are actually saying that there cannot be any post-based at all. Technically, the ratio that falls from what the submission that is sought to be made. Earlier argument was that as interpreted by Gonal Bhimappa and Badami,
Correct.
the rule was there. Now, the intervening amendment was pointed out where the word vacancy was taken out. So that is where it stood at.
Correct.
Now, my lords, in response to that, when it stood at that, before, my lords, we could further continue our arguments. Now they're relying upon two judgments of 1999.
Hmm.
I just want to clarify on those two things, my lords, because I did not have a copy of that.
Correct. There are two slight aspects that
Please, my lords,
the mind of the court
please,
that we
please,
are, 2016, you say
please,
henceforth.
please.
Therefore, it is not on the basis of the 94 amendment
Please.
and the taking away of the quota rule that
No, no, that's.
you are issuing the 2016 circular.
No, no,
Just
no, no,
just
and
putting
even
it
if,
to you.
no,
We'd
even,
like an answer on that. as
please,
well.
my lords, please, because not, I will also go to the extent of saying, automatic, when 94 amendment, the amendment came about, it did not, the state did not say that we have shifted to a post-based regime.
You did not.
It was not that.
You
We
did.
in fact continued operating
Continued
those,
on the
continued
87
operating
on
those
the 87.
OMs.
Yes.
But again, my lords, our argument would be, I just, I'll also put it out,
Yes.
that it was only on the basis on OM. So the entire argument is, since the rule position was interpreted as in, so, and their main submission was the same rule that was in force as on that day,
Correct.
continued in force, my lords, as on the day, my lords, of their.
We are just saying, apparently
Please.
you also thought so. We just, we
Please.
are just
No, my lords,
saying
in-
that
no,
apparently
my
you
lords,
also
in
thought.
fact, when Bhagwat sir was saying they should have brought it to the notice of the court,
Yes.
I was telling my lords Vikas that we are the rule framers, we should have brought it, so we'll just keep quiet is what I said.
Because even in the circular, you don't have such a case.
Please, my lords,
Because in the 2018 amendment,
please,
it appears that a lot of things have been said.
please.
94 amendment. is
No, no,
not-
it has not been said.
not referred to.
It has not been referred. So we are, it is in response to an argument, my lords, of the other side. But the rationale of actually bringing it about was only RK Sabarwal. That is part of the pleading itself.
Correct.
I will clarify only on those aspects. And if any other respondent wants to argue, let them close it, then right of reply. my lords. So in
The entire seniority now in the present case is regulated, but of course, my lord, there is a main, the parent rules are there. 5776 and 14/12/87. This is one in addition to supplemental to the other. And I just wanted to again repeat it. Quota rule is different. Determination of a seniority principles are different. So therefore, this post-based or vacancy-based, I shall elucidate at the next date of hearing.
Shall we continue on the next day, brother?
Yes, madam. Yes.
lords, one,
Therefore, what remains is only with regard to your arguments on the circular and the reply.
Please.
And of
Can-
course, with
in
regard to
response to
the
today's argument,
two judgments which have been referred to today.
please.
Yes,
Let not say.
we'll definitely look forward to after the arguments, a consolidated synopsis.
Please, from all sides.
Because the arguments seem to be evolving in ways that none of us contemplated. Therefore, there are further arguments which are not part of any of the pleadings.
All these,
After the arguments, we look
all
forward
these
to
arose, my lords, because
correct.
the concept of post-based shift, saying that OM is controlling and all, that was never addressed before earlier. Then, my lords, only when my learned friends started reading R.K. Sabharwal.
No, there is one more doubt because Senior Counsel Mr. Udayola was saying about some overriding effect of a general rule.
General
No,
recruitment rules.
we are wondering whether there are any more
No, general
hairs to
recruitment.
come out of the
That has been
hat.
considered, my lords, in V.V. Badami. Rule 17 of the general recruitment rule says, against a direct recruitment vacancy.
That is all. It is not any other
No,
surprise.
this is the only thing. In fact, that rule I read out.
That is all. That we'll consider.
Palla sir reserved right to reply,
Correct.
but in the reply it should not be a fresh argument. So I have to again respond, my lord. And in case if senior wants to argue for 10 minutes or some time on next date, first let him so that we can reply and close it. That also can be done.
Probably that may also.
I think rule
If there are any more surprises, we don't want to be caught unawares.
Rule 17 blood has undergone some change after this.
That probably
Of
is what is
general
being
recruitment.
referred to. We'll look into that.
But in fact, my lord, that 1994 rules,
Yes.
I could find out, my lord, only during lunch hour. It was not a,
And of
Yeah,
course,
not,
of course, absolutely, we are. it
to
is-
give,
there
it
is
was not intended to, my lord, to give surprise to other side.
My lords,
We were also not aware of.
even after 1994 rules came, until 2017, they have
Correct.
prepared the seniority list,
Correct,
taking the quota rule as vacancy based.
correct, which is why
But,
Alternate age said, therefore,
not disputed at all.
even 2018 rule I would not have placed, but because it was a part of the cadre strength notification.
Correct,
One argument I advanced was, assuming that you are changing it, it can only for the increase in cadre strength beyond what it was prevailing as on 23/3/2016. My argument before the tribunal was, after 23/3, as on 23/3/2016, from there, cadre strength has been reduced. Therefore, there is no question of applying
Correct.
that. That was my statement.
But the argument of the petitioners that, my lord, we are covered under the recruitment rules. Since recruitment rules says vacancy is not available is our submission. That may not be on facts, my lord, that is not correct.
I don't know, my lords, if seniority rule is not linked to recruitment rule, to what other rule it can be recruited?
No,
It can be
that is the arguments of the petitioners, that recruitment rules itself says vacancy. That is, my lord, that may not be.
One mentioning in serial number 2, notice was issued. The writ petition papers have to be put up.
yes,
now.
please call for the
And
writ
it may
petition.
be permitted
There
to
are-
take out hand summons because it's a party in person. Please,
Please make out a calculation of the,
please, we'll do that.
that
So
also may have to be handed over to the other side.
We'll,
For them to understand, because it took a while even for us to understand what you're contending.
we'll serve it in advance.
Yes. Yes, brother. Can we list it
Yes,
on the
madam.
30th then?
Yes. In between that, they will get 8 or 9 lunch hours. They may come out with 8 or 9 more notifications.
Yes. Asked my brother to say something like that. I was looking forward to his response. RP also will list on 30th.
Please.
Let's see whether notice is possible.
ಮೇಡಮ್ ಏನೋ ಕೇಳ್ತಿದ್ರು